The trial, the defendant Lyle Menendez is in court with his attorneys. People are represented, and we still have some instructions to resolve here. Did you have some input from counsel for the co-defendant last night as far as some of the discussions we had?
Yes, I hope I understand what the court's rulings were.
They were, what we ultimately did was focus on instructions that the court and counsel for Lyle Menendez had not resolved. And in doing so, discussed instructions that really had been submitted by both defendants, or at least very closely similar instructions or closely related instructions. And then the people today have submitted a couple additional matters for the court to consider. I assume you've had a chance to see them.
Yes. One thing I was not clear on was whether the court was going to give the people's definition of imminent peril.
I don't intend to do that at this point. My view is that as much as I can, I'm going to stick to the standard jury instructions. And if there is need later on for clarification or whatever, it certainly can be done. There was one or two instructions, I think, we had never resolved, and I don't know if they are substantial to the point of having to be resolved prior to argument, but we certainly can discuss them and resolve them if you want to at this stage. One of them had to do with the tape recording of out-of-court statements of the defendant. I don't recall if we did resolve that one.
No, we didn't.
As to how to word that. And counsel were invited to submit to the court any language that you felt you wanted to give to the jury. This is 2.70. Did either side have anything further you wanted to submit?
No, other than the instruction that I did submit to the court.
The earlier version.
Yes, the one that we were asking the court to give was in the first set of additional proposed jury instructions, and it was 2.70 modified. And in the alternative, we just asked the court to give 2.70 unmodified.
And the people's position?
Where, I'm sorry, I think I was under the impression the defense was supposed to modify it. What I would propose is to take their version, the 2.70, cross out the last sentence and put in the evidence of an oral confession or oral admission of the defendant that was not tape recorded should be viewed with caution, or which was not tape recorded. I don't know which is the better, but I could do that at lunch. I could have this one typed up, if that's the language the court's inclined to give.
And that was really the issue.
Yeah,
that was misleading, and it's my position at this late date that the court should simply give 2.70 unmodified and let the parties argue about tape recorders if they want under the standard instruction. But on the facts of this case, it would be misleading for the court to be in a position of instructing the jury that the 1211 tape should not be viewed with caution.
It's the people's position that that's not the state of the law.
Well, I tend to agree with the defense that there are certain aspects to the December 11th tape that might be subject of caution, and for the court to single it out and say that it should not be viewed with caution is highlighting that particular controversial piece of evidence.
But there are lots of other tape recorded statements of the defendant, some of which I think the defense might urge the jury to believe, like the 911 tape. They might urge the jury to believe that that was genuine grief and genuine emotion, and therefore this applies to that particular tape as well. So I don't, it's my understanding that the reason for giving the admonition about viewing things with caution is because of people's, failure of recollection and things like that, for those who would relate a statement that is a police officer or witness to someone like that. And yet,
you can argue that. You can say that's the reason why there is this cautionary phrase in the instruction that relates to the unreliability of human memory or the potential for fabrication, and leave it at that. So I'll give this standard 2.70. I think that's the easiest and best way to deal with that.
and then there's several instructions submitted.
That was the request of the defense, is that right?
Yeah.
So you're gonna do the instruction.
All right, there were some others here. Number 15 and 13 of the defendant's proposed special instructions dealing with heat of passion. The court indicated it would give the first sentence of your proposed number 15, which says a defendant may act in the heat of passion at the time of the killings as a result of a series of events which occur over a considerable period of time, and balance would not be given.
Is the court giving 13?
No,
Okay.
just the 15 with that one sentence. And I left it up to counsel, co-counsel, as to whether they wanted to combine that with the other heat of passion instructions or have it just as a separate instruction.
And the court's also giving 14, it's my understanding.
As modified.
Right.
Let me double check. I think we had discussed that one before.
We had, and were modifications discussed, and it was modified and resubmitted to the court, and
Yeah,
co-counsel represented to me that the court was going to give it.
yeah, I need a type version for this defendant. Of that, which
That was
reads-
submitted yesterday in the second set of proposed.
You submitted it?
Yes,
Oh, let me see.
should be under second set of additional proposed jury
What number was
instructions.
it?
It's called number 14 in their new package.
14 modified.
Yeah, got it. Okay. And also, I indicated I would give the standard 5.17 as language appears in Calgic without the modifications that have been requested by the defense, citing the Uriarte case, just the standard language of 5.17. And I think I indicated when we last discussed the instructions with you folks that I didn't feel that the facts of this case supported the instruction dealing with defense of another relating to the attempt to commit a felony or an atrocious crime. That was not supported by the evidence in this case or by the law, so that I will only give 5.17 in its original version dealing with the reasonable belief in this strike that, the unreasonable belief in the necessity to defend against the infliction of great bodily injury or death.
And I think also in regard to 517, we left pending special instruction number 4 and 5, which state the principle about the person who uses an unreasonable amount of force. And I cited to co-counsel yesterday to be furnished to the court People versus Welch, which supports the extension of flannel to the idea that it applies when the amount of force that's being used is unreasonable.
I'm not so sure that's what Welch was saying. I think Welch was talking about a different theory of manslaughter, not a flannel theory at that point in its opinion. It was talking about excessive force or more force than was necessary under the circumstances. It's not a flannel type situation, but a reasonable self-defense situation and an overreaction. Like that's what that part of, that's how I read that part of Welch.
Well, it was my understanding Welch was talking about a situation where the defendant acts without intent to kill and therefore is entitled to an involuntary manslaughter instruction.
Yeah, that's a separate issue.
Right, and in that context, I thought the court was discussing flannel. Maybe I'm wrong, but that's the way I read it.
Well, there was discussion of flannel, but also there were other elements of the theories for involuntary manslaughter in that case.
So then 4 and 5 would not be good.
Well, let me look at your 4 and 5 once more after I review Welsh one again. Yeah, in Welsh, on page 840, the circumstances of that case where there was a physical confrontation face-to-face between the defendant and the deceased, the court stated in that context of that fact situation, the jury could reasonably believe that the defendant's actions were taken in self-defense compelled by fear of great bodily harm or death. If such were the case, a conviction for involuntary manslaughter would be appropriate where the jury finds that the nature of the attack did not justify the resort to deadly force in self-defense or that the force used in self-defense exceeded that which was reasonably necessary to repel attack, citing People versus Clark and People versus Young. And earlier, that opinion defines involuntary manslaughter using the statutory definition, which really would not apply if flannel was the circumstance, because flannel, if it drops something from murder down to involuntary manslaughter, doesn't do so by applying the statutory definition of involuntary manslaughter as found in 192 of the Penal Code, which has language in the commission of an unlawful act not amounting to a felony or in the commission of a lawful act which might produce death in an unlawful manner or without due caution and circumspection. The negligent type, gross negligence situations. Flannel reduces a killing to involuntary manslaughter if there is evidence to support and the jury finds that there was an honest but unreasonable belief in the necessity to defend and concludes therefrom that and by that there was no malice aforethought, reducing it to manslaughter. And then manslaughter is defined as an unlawful killing of a human being. And the jury is deciding that there's unlawful killing by deciding that there was unreasonable force and the belief was unreasonable in the need to use force. And then the issue is whether there was an intent to kill. And the way this case reads, it's really talking about a different type of situation, the gross negligence manslaughter situation, not the flannel reduction situation, as I look at it. There is flannel in it, and it's a separate issue regarding flannel and the intent to kill. And it cites flannel for the proposition relating to the burden of proof on the trial court, the burden on the trial court to instruct based on the level of evidence introduced. So I don't find that Welsh is apposite, and those. Let me look at those instructions, however, because regardless of Welsh, they might still have bearing on the subject. Those are 3 and 4 or 4 and 5?
4 and 5.
4 and 5. And of those two, since the court is 5 merely combines 517 with the concept that is discussed in 4, since the court's going to give 517, of those 2 instructions, we would be asking that the court give number 4.
我曾经很烦川普这个人，但说真的，在他执政期间，买菜比现在便宜，油价也比现在低，没有那么多不知底细的非法移民。我的城市比现在干净安全的多，晚上出个门也不必提心吊胆。相比哈里斯拜登执政这4年，川普在的时候，我的日子要好过得多。如果你也有同感，请为川普投票，毕竟我们选的是能办事的总统，又不是提供情绪价值的老公。
Paid for by Common Sense Maryland PAC and not authorized by any candidate or candidates committee.
I think 4 is duplicative of 517 as well, because 517 talks about unreasonable belief in the need to use force. Yeah, this is just a duplication of that, isn't it?
So the court is saying within the concept of 517, it would appear to be permissible to argue that someone who's disabled and is therefore not rendering any sort of threat, if the person nevertheless in good faith believes that that person represents a danger, that situation is covered by flannel.
Well,
It's an excessive force situation, and therefore perfect self-defense doesn't apply, but it seems 517 is broad enough to cover that situation.
Well, I'm saying that 517 talks about the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. That is the focus on the unreasonable belief in the necessity to defend. Now, when you get to a certain point, is that an honest belief when you use excessive force? That's a separate focus. And I don't think this instruction you're proposing deals with that. You still have that honest belief aspect as at some point force becomes, or the belief becomes so unreasonable that it's not an honest belief. And the jury's entitled to evaluate it in that context. All right, what is the people's position on number 4 and 5?
Your Honor, it's people's position that number 4, especially is a hybridization of flannel and the defense theory, but it's not a correct statement of the law. And that if in fact, in this particular case, if you believe the defendants that they feared that they were about to die, then I don't think the issue raised by the defense in instruction 4 gets reached. I mean, it seems like a hyper-technical point considering the facts of the case.
Well, if it was a appropriate statement of law, I would disagree. But I don't. In the context of 5.17, I don't think it is necessary. Number 1, and I don't think it's an appropriate statement at this point of the law. So I'm going to deny 4 and 5. think I actually had done that before when we had discussed it from my notes here. And just to complete, the court indicated it would give the special instruction number 3 submitted by the defense regarding prior threats, and number 10 regarding character of the victim, number 14 regarding the nature of the passion. And we did not discuss yesterday with the co-counsel number 22 or resolve it. What is the people's position regarding number 22?
It's people's position this should not be given. It's not a correct statement of the law, and there are instructions which deal with provocation, reducing a first to a second, which the court is going to give. And since the people's theory of murder is not lying in wait, and the court is not instructing on lying in wait as a theory of premeditation, I think this is confusing as well, because it appears to be commingling lying in wait as a theory of murder versus a special circumstance with premeditation and deliberation. And the people are not relying on lying in wait as a theory of murder.
Do you wish to respond?
Yes, the court will notice in the Calgic instructions that Calgic deals separately with the mental state requirements for the underlying charges and has a separate instruction for the special circumstance. For instance, on the sufficiency of circumstantial evidence to prove specific intent, there's an instruction which goes to the elements, and there's a separate instruction which goes to the special circumstance allegation.
Right.
And in the case of the lying in wait allegation, the last sentence of the standard instruction on lying in wait, that would be 8.81.5.
Now, what are you talking about? I'm talking about special instruction number 22, which deals with provocation.
Yes, that's what I'm talking
Okay.
about. The standard instruction on lying in wait has a line in it which says the lying in wait need not continue for any particular period of time, provided that its duration is such as to show a state of mind equivalent to premeditation or deliberation. So the state of mind on the special circumstance allegation is premeditation, something equivalent to premeditation or deliberation. 8.73 deals with using evidence of provocation to reduce premeditation or deliberation in the context of the underlying charge, where first-degree murder based on premeditation and deliberation are charged. But it does not deal with how the jury uses evidence of provocation, if at all, to reduce the charge, the special circumstance allegation in the mental state, which is equivalent to premeditation and deliberation. I think the CJA case, CEJA, which we cited to the court, although it doesn't directly address the issue, it assumes that heat of passion can reduce a lying in wait allegation down to manslaughter. So I think it, and in that case, it said the evidence was insufficient to reduce it down. But the underlying assumption of that case is that provocation is relevant to lying in wait, because lying in wait is simply another means of getting at premeditation or deliberation. And that being the case, the jury should be informed that it could take into account provocation as well as the unreasonable belief doctrine in a situation. If they find it insufficient to reduce it to manslaughter, they still could use the provocation evidence or the unreasonable belief evidence on the issue of deliberation or premeditation as it applies to the special circumstance allegation. So I think it is a correct statement of the law, and it's not otherwise covered by Calgic.
Well, standard 8.73 provides that the jury may consider provocation as it relates to first or second degree murder. As it relates to premeditation and deliberation, although it doesn't say that, that is what is inferred from 8.73. And to the extent that premeditation and deliberation are referred to in the instruction on lying in wait, then you have that argument, do you not? It just takes you a few extra words to express what it is that you're proposing to be done in this instruction.
Well, it's a few extra words, but in view of the importance of the special circumstance allegation and in view of Calgic's pattern here of directly addressing these principles as they apply to the special circumstance allegation, I don't think it's unreasonable for the court to address the issue separately so that there's no misunderstanding that this concept does in fact apply to the special as well as to the underlying theory of first degree murder. You can certainly infer that from the court's instructions, but why leave something like that to inference?
Well, all I would suggest then is 8.73 can be modified to add another sentence saying that you may also consider that provocation in relationship to your determination of the special circumstance of lying in wait. Something along those lines.
Well, that would cover part of the problem, which is extending provocation to the special circumstance allegation, but 8.73 also does not deal with whether honest but unreasonable belief can be used to reduce first degree down to second, and whether that same belief can be used or applied to the special circumstance allegation. It does indirectly in the definition of premeditation and deliberation, but it is not spelled out in the way it should be.
All right, I am going to reject number 22 as duplicative of other instructions. I would be inclined to modify 8.73 to include a second or another sentence relating that issue to the subject of the special circumstance. And if you want that, I'll give that.
Yes, we would ask that that be given in the alternative.
All right. And as far as 8.81.15, the people have submitted something today. Have you had a chance to see that?
Yes, I have, Your Honor. We are objecting to the people's additional language because in Edwards, it was only the sentence which the defense proposed, and the sentence is, if the murder is done suddenly without a period of waiting, watching, and concealment, the special circumstance of lying in wait is not present. It was that language that the court zeroed in on when it addressed the issue of whether the instruction is modified, spelled out the requirement of a substantial period of watchful waiting. And the court did not address and did not approve the additional language which was given in that case, and which, if you read it, seems to dilute the requirement of a substantial period of watchful waiting. No other instruction in Calgic is like the lying in wait instruction in focusing so much of the jury's attention on what the requirements, what the elements do not require. The whole instruction is written by Calgic is already overly argumentative in favor of the prosecution, telling the jury that the jury need not find X, Y, Z in order to find the special circumstance to be true. And the reason the defense proposed the one additional sentence they asked for was because it gives some balance to the instruction in pointing out that there are requirements. And one of the requirements is a period of a substantial period of watchful waiting. And I think the sentence we propose does that. It's the language that was approved in Edwards, and the additional language is argumentative and dilutes the element that the defense is going to focus on there.
All right, people wish to argue that.
Yes, Your Honor. With respect to 8.81.15, the language that was considered in People versus Edwards was pre-moralis. That is, the trial court gave instructions without the benefit of the Morales case, the California Supreme Court's pronouncements in Morales. The court went on to say at page 823 that based on the instructions given by the trial court in Edwards, it was sufficient even under the new pronouncements of Morales. What the defense does is takes one sentence out of the paragraph concerning the instructions actually given by the trial court and asks the court to give that alone. We now have the present Calgic 8.81.15 based on Morales. I think that's sufficient. If the court intends to give the language out of Edwards, then I'd ask that the whole context be given. That is the whole paragraph, rather than have the defense pull out one sentence out of that case.
All right, the nature of the additions by the prosecution are argumentative, and I'm not going to give it. I think the submission by the defense is an accurate statement of the law, and I will give it as it's been presented by the defense. The people's version is rejected. What about any other instructions here? People had submitted a citation to People versus Horn. What was that for?
That's with respect to defense special instruction number 19 for this defendant and 16 as to the co-defendant.
Yeah, what were you proposing?
Well, the language of that particular proposed instruction is not an accurate reflection of the law. What it states in the first sentence is, the fact that a killing was planned in advance, whether individually or in concert, does not prove that the planner acted with malice. Now, what the defense again does is take a sentence out of context. What the court was saying is that it does not automatically and conclusively prove that the planner acted with malice. That is, I believe it's misleading for them to say that simply it does not prove this, when I think even the Horn court would acknowledge that in most situations it does in fact do just that. So I object to the language as stated in this instruction. I think it's misleading.
I think that we covered this ground, and the court said it was going to give this instruction, and the language is taken exactly from People versus Horn, and the exact page that counsel has provided to the court this morning, page 299. It's verbatim from Horn.
But the language that says that it does not conclusively prove has been changed by the defense does not prove, which means doesn't prove it at all.
It hasn't been changed. The next sentence down says, consequently, the fact that a killing was planned in advance, whether individually or in concert, does not prove that the planner acted, etc. And that's exactly the language that the court said it would give.
Yeah, that's been resolved, and I'm going to give it. All right. Any other instructions that counsel wish to discuss?
The only other instruction, I'm going over the final submissions of instructions that I was concerned about, was the instruction 6.26, which explains to the jury the findings on the objects of the conspiracy. And in the form submitted by the defense, we had asked that two options be given. Number one, the murder of Jose and Mary Louise Menendez in violation of Penal Code Section 187. Number two, manslaughter. And I think under Horn that the jury is also required to specify whether the object was first degree or second degree.
People wish to be heard.
No, Your Honor.
Does that mean you agree with that?
I think that's fine.
All right. Any other issues that you want to discuss?
No, you.
I don't know if we finished off the discussion with this defendant in relationship to the request for involuntary manslaughter. I had indicated to you my feelings in that regard. We had further discussions yesterday with the co-defendant stating his position. Did you wish to be heard further on that?
No, as I indicated to the court the other day, we're relying primarily on the testimony of Dr. Burgess as to a lack of intent to kill. And also there are, in reviewing the testimony of Lyle Menendez, several places in his testimony where he indicates he was not consciously thinking. Ms. Bozanich focuses attention on, well, what was he thinking at the moment when he pulled the trigger regarding the shot on his mother? And he said he was not consciously thinking at all. And then Dr. Burgess testified about the automatic response. So,
well, certainly her testimony didn't relate to the defendants themselves, and was not received and could not be received for that purpose.
that's true.
To show any diminished capacity or anything of that nature.
Well, she was testifying in general to a fear reaction, and I think she said it would apply to anybody in the situation that the evidence otherwise proved the defendant was in.
Yeah. Did anyone ever specifically ask this defendant whether he intended to kill his mother or father?
Not in those terms, no.
Did the defendant ever testify he did not intend to kill his mother or father?
No, not in those terms.
What is the people's response to the inquiries I've just made?
Your Honor, I can't cite the court to a specific page, but I believe in cross-examination it was made very clear that he knew when he went in the room he was going to kill his parents.
When you say it was made very clear, you mean
It's
that's from the circumstantial evidence or from his statement?
From his testimony during on the witness stand, that he knew that he was shooting at people. He knew that he was shooting his parents. He indicated that he's the one that delivered the contact wound to the back of his father's head and the contact wound to his mother's cheek. He knew they were human beings, and the defendant's claim of automatic action, I don't think is to be believed and does not justify the giving of an involuntary manslaughter instruction.
Well, as far as whether something is to be believed or not, that's for the jury to decide. It's a question of whether there is sufficient evidence for the court to instruct on the theory of involuntary manslaughter.
Well, it's the people's position there's not a theory of involuntary manslaughter which fits the facts of his case.
Well, the theory would be that there was an unlawful killing without an intent to kill.
Right, and I think it's clear from the testimony of the defendant that when he went in there with his shotgun, he went out to the car, unloaded it, reloaded it with better shot. He went from birdshot to buckshot, went inside and started shooting his parents. I don't think his intent to kill could be any clearer than that. And in spite of what Dr. Burgess or the defendant might say, I think it's very clear from the circumstantial evidence and the cross-examination of the defendant that he intended to kill his parents.
Well, the cross-examination includes a question by Ms. Bozanich at 15,237. Question, you went into that room and started firing your weapon before you even knew what your parents were doing, didn't you? Answer, yes, we were in a panic. And then at page 15,253, question, and so your father was not going to your mother anymore. Answer, I wasn't thinking that. I didn't know, wasn't thinking as it was happening. This happened so fast, I was just reacting. And I think that's and then when she zeroed in on, well, what were you thinking when you put the gun up against your father's head and your mother's cheek? The response was the same. I was just reacting.
Additionally, Your Honor, I think when asked specifically about the shot to his father's head, his answer was, I don't remember doing it, but I must have. And with regard to the last shot to his mother, he indicated that he didn't look, he reached over. So there's nothing specific in terms of intent at those times.
Right. The issue is whether or not there's sufficient evidence to justify the giving of the instruction, not sufficient evidence to, it's not for the court to evaluate that evidence and weigh it and tell you how I would decide the issue. It's just whether or not there's sufficient evidence for it to go to the jury on the theory that there was an unreasonable belief in the need to defend, making it an unlawful killing. And if there was no intent to kill, then it's involuntary manslaughter. If there wasn't intent to kill, then it's voluntary manslaughter. That's the defense theory. What is the defense position in regards to the implied malice concept?
I think we discussed it before, and was our position that it would simplify matters not to give it.
That just express malice and nothing else?
Yes.
What is the people's position, assuming the court did give involuntary manslaughter, whether or not the people would want
I think then implied malice should be given if the court is going to give involuntary manslaughter. But if that's the case, then I think I have to redo all my charts for the jury, because I've based my argument on the presumption that the court's not going to give implied malice or involuntary manslaughter.
That also applies to us, Your Honor.
Well, I don't intend to delay things very long for that.
Mm-hmm.
Right. So the people's position is that you would want implied malice, and if there was involuntary manslaughter, is that right?
Yes.
Okay. Well, in reconsidering the issue and analyzing it, not along the lines that the defense has submitted initially, because the defense did submit certain instructions regarding involuntary manslaughter that related to the statutory definition of involuntary manslaughter, which is not really what the definition is that would be provided to the jury. The definition that would be provided to the jury is one judicially created, if at all, by the Supreme Court in its decision in Flannel, that if there is an unlawful killing, then the killing is to be evaluated along the lines of whether there was an intent to kill or not. If there was no malice aforethought, if there was intent to kill, then it's voluntary manslaughter. If there was not intent to kill, then it's involuntary manslaughter. And unless the people can tell me as a matter of law, there is no evidence in this case that would support a finding of involuntary manslaughter, the court feels it would be obligated to give that instruction. You argued the case as far as how you view the evidence, as to how you would argue the case to the jury, how you would convince the jury that there really isn't any, but there is evidence offered by the defense of that would support involuntary manslaughter. So it's for the jury to make that decision. And therefore the court would give an involuntary manslaughter instruction, a very simplistic one, which would conform with the dictates of Flannel as to how a murder is reduced, and it would be just definition of involuntary manslaughter as unlawful killing of a human being without malice aforethought and without intent to kill. How does the defense respond to that definition?
We have no objection to that.
Is that what you're requesting?
Yes. Could I have one moment to talk to counsel about the implied malice
Yes.
instruction? Reach an agreement. We can't. So
All right. What was it that you were trying to?
this is on the implied malice and whether it was my position that it would simplify the instructions if the court just gave express malice. But I think in light of the involuntary manslaughter instruction, the court would probably have to give the implied malice instruction.
I would feel uncomfortable not giving it in light of the defense argument that if the jury was to find there was no intent to kill under these circumstances, that it should be reduced to an involuntary manslaughter when the implied malice definition could also apply. But again, it would only apply if there was a finding by the jury that there was a good faith but unreasonable belief in the necessity to defend, negating malice. But again, that's up to the parties. If you want it, you can have it. If you don't want it, you don't have to have it. All right, so the court would give implied malice as well. All right, how much time then would you need to rearrange your charts and your thoughts?
Your Honor, I just need to go back to the office and get a copy of 8.11 unmodified, and then just won't use the chart.
Well,
So-
I have no objection to using unmodified charts as long as it's made clear that there's another theory. That's what I intended to do. Since my charts only had express malice, I was going to say the court's also going to instruct you on implied malice.
Okay.
It's not on the chart, but I don't see any objection as long as,
Right, that's fine. I just need to go get a
I'll
copy.
give you, I can give you a copy of that.
All right, and I need to go to the latest room.
Oh, sure. We'll do that. Oh, actually, I don't have it here. So what I'll do is I just, if you want to take your break now and get it, do that. And what we'll do is resume at, can you be back and ready at 10:15?
Yes, Your Honor, there's one thing I wanted to ask the court. I have my argument broken up into 4 parts. And is the court going to give the jury a break this morning if we start at 10:15?
Only of necessity. If
All right.
we could go ahead and straight through, I'd just soon do that.
Okay, I was going to, I'm not sure I can finish if we start at 10:15, but I'm going to still try. And if the jury needs a break, I'd like to finish at the end of my second part. I just wanted to complete a couple things before we took a
All right,
break.
you let me know.
All right.
We're going.
Your Honor, there's one other matter with respect to the photographs. May I mark those next exhibits in order? Both the ones that the people have submitted and the court has looked at and the ones that the defense has submitted.
Well, I don't know what the position of this defendant is on those
May I
photographs.
be excused while the
Yeah, sure.
photographs are being discussed?
Had you seen those photographs?
You've seen them. They're the same ones that we had the other day.
Yeah, I've seen
We're just waiting.
various photos at various times. I don't know what discussions were had
Okay,
after we
I'm
left.
going to just cut it off and say that photographs aren't going to be used. Otherwise, we're just going into more evidence, introducing evidence. Both sides are arrested as far as I'm concerned. We're not going to use any evidence of those photographs, period.
With respect to the other jury as well?
That's it.
Your Honor, it was my understanding that when we ended on Friday, that this was an issue that would be addressed, and I brought it
Yeah,
to the court's
you did.
attention.
You did, and had it been brought to my attention for resolution, if you had forcefully brought it to a head earlier in the trial, it could have been. But
We
that
didn't
late
get
stage.
the photographs
Well, you
until
didn't
that
pursue
very
it
day, Your
until,
Honor.
I know, you didn't pursue it vigorously until that very day, so it wasn't something that could be resolved then. And at this point, I'm ruling that that's the end of it. No more evidence. We're just going to go ahead with the argument. So take a break, and in 15 minutes, we'll have the jury in and we'll start. And as I've indicated to you throughout the trial, the statements of counsel are not evidence. You have heard all of the evidence and seen all the evidence in the case. And at this point, what the lawyers do is comment on the evidence, give you their interpretation of the evidence that you've heard. Ultimately, you are the judges of the evidence. You determine what happened in this case based on the evidence that you've seen and heard in the courtroom. But the lawyers obviously have important things to say as to how they interpret the evidence. And the argument will proceed first with prosecution, then defense, both defense counsel, then the prosecution has a chance to complete argument. And hopefully by Friday, argument will have been completed, and I will instruct the jury on all the legal rules, and then you'll begin your deliberations. All right, you may proceed.
Thank you. I'd like to reiterate what the judge just told you. This has been a very long trial, and I will make mistakes in reciting to you the evidence. I don't think there's any chance I won't make some mistakes. And if your view of what the evidence was conflicts with what I tell you, obviously it's your view, because you're the ones who are now going to decide this case. And so keep in mind that this has been a long trial, and that what we say is meant to persuade you. It's not meant to, it's attempted to be 100% accurate, but I can't guarantee that it will. And in light of that, I'd like to point out that 17 weeks ago this Friday, 17 weeks, the people of the state of California rested their case. It was August the 13th of this year, and August was a very long time ago. At the time that the people of the state of California rested their case in chief, this was a murder trial. And as soon as the defense of the case began, it became anything but a murder trial. What I'm here to tell you today is that you have to concentrate now on the murders of Jose and Mary Louise Menendez. I have up on the board an exhibit which is number 7, and I'm not going to discuss a lot of the exhibits with you, but you're going to have over 200 exhibits for your perusal if you need them during the course of your deliberation. But the exhibit on the board is why we are here. We are not here to discuss whether or not Dr. Oziel should be sued for palimony by Judalon Smith. We are not here to try Mr. and Mrs. Menendez for being bad parents. We are not here to try Jose Menendez for being an alleged, not a convicted, but an alleged child molester. And we are not here in the psychological malpractice trial of Dr. Oziel. What's going to happen at the end of argument, I'm going to try to restrict my argument to the morning session, but I may go a little bit into the afternoon. And the defense attorneys will then argue to you, and then I will have a chance to argue again. At the end of our arguments, the judge is going to instruct you on the law. And you're not going to get any law dealing with child molesters or bad psychologists or bad parents. The law that you're going to get deals with homicide. It deals with murder. And that's what this trial is. It is a murder trial. When the judge instructs you on the law, he's going to instruct you on 4 theories dealing with homicide. And I'm going to use charts, not too many of them, to try to illustrate what you're going to hear from the judge. As I just said, this is a trial dealing with homicide. And homicide is very simple. Homicide is that a human being was killed, that the killing was unlawful, and that the killing was done with malice or forethought. That's what this is, the law of murder, all right? And it's the people's contention that this is a murder trial. This is not a manslaughter trial. The defense attorneys are going to argue to you the law of manslaughter. But what I need to point out to you right away is that there are only 4 things that you could convict this defendant of: first-degree murder, second-degree murder, voluntary manslaughter, or involuntary manslaughter. There is no theory by which you can acquit this defendant. There is no legal theory by which you can find Lyle Menendez not guilty. So keep in mind during your deliberations that in order for you to find him not guilty, you would have to ignore the law in this case. The judge is going to instruct you that this is either first-degree murder, second-degree murder, voluntary manslaughter, or involuntary manslaughter. Those are your 4 choices. You will be getting a not guilty form, but in order to fill out that not guilty form, you would have to ignore the judge's instructions. Now, you're going to get some other instructions in this case dealing with the law of conspiracy, and you're also going to get some instructions that deal with things called special circumstances, and I'm going to discuss them in the first part of my presentation. Premeditated first-degree murder, and I don't have a chart for that because it's a very long definition, but basically premeditated first-degree murder is where you kill someone, you plan to kill them, you think about it, and you do it anyway. Premeditated murder, the judge will instruct you in as I said, a rather lengthy instruction, but you all have an idea in your heads of what premeditated murder is. Premeditated murder is when you think about it, you plan it out, you carefully weigh and consider it, and you do it kind of cold-bloodedly, and that is premeditated first-degree murder. The only theory of first-degree murder that the people are going to urge on you is this theory, which what it is premeditated, cold-blooded, calculated murder. Let me read to you part of the instruction. If you find that the killing was preceded and accompanied by a clear, deliberate intent on the part of the defendant to kill, which was the result of deliberation and premeditation, so that it must have been formed upon pre-existing reflection and not under a sudden heat of passion or other condition precluding the idea of deliberation, it is murder of the first degree. What the defense will argue to you is that the defense theory of the case means that there is no premeditation. They're going to argue to you that the events that occurred between August the 15th and August the 20th clearly show no premeditation. So that's one of the key points that we're going to be arguing over. This particular instruction goes on to say that the true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it included an intent to kill, is not such deliberation and premeditation as will fix an unlawful killing as murder of the first degree. The slayer must weigh and consider the question of killing and the reasons for and against such a choice, and, having in mind the consequences, he decides to and does kill. It's very specific as to what constitutes premeditated murder. The people of the state of California have proved to you that Lyle Menendez, accompanied by his brother, planned this murder. I would like to refer you again to the tape from December 11th, which was played for you near the end of the trial by the defense. But in that tape, where you hear the voices of Dr. Oziel, Lyle Menendez, and Eric Menendez, you hear Lyle Menendez, unprompted by Dr. Oziel, talking about planning and planning to kill. And he talks about the fact that he gave his brother a couple of nights to sleep on the decision to kill mom. And implicit in that is that it was a decision to kill mom that was coldly and carefully arrived at. Now, the defense is going to tell you that what happened is these defendants were in a constant and heightened state of fear between the 15th of August and the 20th of August. But the evidence in this case, not the defendant's words, but the physical, circumstantial evidence in this case disproves the defense theory. I'll get into that some more later. The second kind of murder that you're going to hear about is murder of the second degree. Your Honor, may I have some water, please?
Yes, sir.
Thanks. Second degree murder is still murder. Society recognizes that when you kill someone, there are all different reasons and kinds of killings. Second degree murder is a murder, that is a crime that's committed with malice aforethought. But it's not premeditated. It's something that occurs with less forethought, with less calculation, and with less care. Now, there are two theories dealing with malice aforethought and the way that it applies to second degree murder. And I'll tell you what that is. Malice aforethought is either express or implied. And this particular thing that I'm going to read to you deals very specifically with second degree murder, which again is unpremeditated murder. Malice is express when there is manifested an intention unlawfully to kill a human being. Malice is implied when the killing resulted from an intentional act, the natural consequences of the act are dangerous to human life, and the act was deliberately performed with knowledge of the danger to and with conscious disregard for human life. When it is shown that a killing resulted from the intentional doing of an act with express or implied malice, no other mental state need be shown to establish the mental state of malice aforethought. The mental state constituting malice aforethought does not necessarily require an ill will or hatred of the person killed. Keep in mind that malice, the way you might use it in your ordinary language, is not the same as the legal definition of malice. The word aforethought does not imply deliberation or the lapse of a considerable time. It only means that the required mental state preceded rather than followed the act. Now, in this particular case, it's the people's theory that second degree murder does not apply to the facts. This was an intentional killing that was planned. This was not an act that just occurred at the spur of the moment without planning and calculation. And again, I will discuss with you a little later what the elements that we feel show that this was premeditated versus something that was done on the spur of the moment. The next theory of homicide that the judge will instruct you on is voluntary manslaughter. And this, I believe, will be where the defense will concentrate their argument dealing with the law. Voluntary manslaughter is where a human being was killed, the killing was unlawful, and the killing was done with an intent to kill. Voluntary manslaughter is of two kinds. There's voluntary manslaughter where there's been a sudden quarrel or heat of passion. I think the classic case of voluntary manslaughter is a person finding their spouse being unfaithful to them right in front of them. And in the heat of the moment, the person kills their spouse. Or if you want to be really fair, kills the spouse and the person with the spouse. That's a classic case of heat of passion. The other thing that you're going to hear about is another theory. It's a theory of manslaughter that reduces a murder to a manslaughter. And I will discuss this with you now. The key to the defense case, and I think the reason that you heard the kind of evidence that you heard, is so that the defendant will be convicted of a manslaughter. Now, one of the theories is heat of passion and provocation, and the defense attorneys will argue to you that the lifetime of abusive conduct by their parents fed them and fed their fear so that the events which occurred between August the 15th and August the 20th make sense. And what the defense wants you to do is to convict their client of voluntary manslaughter, or better yet, of involuntary manslaughter, based upon this particular instruction, which is a person who kills another person in the honest but unreasonable belief. Now, keep in mind, it's got to be an honest belief. In the necessity to defend against imminent peril. Keep in mind the word imminent here. To life or great bodily injury. Kills unlawfully, but does not harbor malice, aforethought, and so is therefore not guilty of murder. This particular instruction is used to reduce a murder to a manslaughter. Now, keep in mind, these instructions are very difficult. Murder instructions are the most difficult of them all. And so it may take a while for these concepts to sink in. Took me a long time to figure out the difference between these different kinds of killings. To continue on, this would be so even though a reasonable person in the same situation, seeing and knowing the same facts, would not have had the same belief. In other words, if you sitting here in the jury box look at the facts in this case and you think, I don't understand why they did what they did, I wouldn't have acted that way. Still, the standard is whether the defendant honestly but unreasonably believed in the need to defend himself from imminent peril. Such an honest but unreasonable belief is not a defense to the crime of voluntary or involuntary manslaughter. Now, what this last sentence here means simply is that if you have a killing and you are saying that you honestly but unreasonably believed in the need to defend yourself, then the killing is either a voluntary or an involuntary manslaughter, but it's not guilty. So this particular concept of an honest, unreasonable belief in necessity of self-defense as to imminent peril means that the defendant is not convicted of murder, but he's convicted of either voluntary or involuntary manslaughter. So your four choices, again, are first-degree murder, second-degree murder, and second-degree murder really is, it's not a manslaughter, and it's not premeditated murder, but it's a killing with malice aforethought. And to me, and it's always seemed to me that that's a little bit hard to fathom. But if you look at it as being a intentional killing, or a killing done where you're shooting at someone and you should know that you're going to hit someone, because anybody would know that if you shoot it, or if I started shooting at a room full of people, I may not have premeditated it, but that act is so callous that I am going to hit someone and someone's going to be hurt. Or if you take your car and you drive it into a crowd of people, you may not intend to kill a particular person, but that act is so dangerous that malice is implied from the doing of the act. Now, the defense may want to argue that by going into the family den and shooting at the parents, that this is only a second-degree murder because the defendant really hadn't premeditated and really hadn't thought it out. But I submit to you that the evidence in this case of premeditation is very strong. The other instructions, now you're going to get some other instructions, and one of the things that you're going to be told that is that the people have charged a conspiracy. See, count 1 in this case deals with one parent, count 2 deals with another parent. And I'd like to point out to you that in spite of the defense efforts to commingle Mr. and Mrs. Menendez into one person, and in other words, they were the united front confronting these defendants, they are 2 separate people. They are 2 separate human beings, and you have 1 count of murder for one and 1 count of murder for the other. And I would ask you to pay particular attention to the fact that there are 2 human beings here who were killed. And in spite of the defense protestations to the contrary, they may have been killed for very different reasons. The 3rd count of the indictment is a conspiracy to commit murder. Conspiracy to commit murder and the lesser offense of conspiracy to commit voluntary manslaughter is as it sounds. And what we've alleged is that in order to prove that there was this agreement among the defendants to kill their parents, on August the 18th, they purchased 2 Mossberg shotguns in San Diego. Well, we know that's true. They admitted it on the stand. But before they admitted it on the stand, the people proved it. The second thing is that on or before August the 20th, they acquired shotgun ammunition. The testimony of the 2 defendants is that on Saturday morning, the 19th of August, they in fact went to Van Nuys and acquired further shotgun ammunition in order to kill their parents. So that particular overt act has been proved by their own testimony. And the last thing is that on August the 20th, the day of the murders, Lyle Menendez contacted his friend Perry Berman by telephone to arrange a meeting later that night to serve as an alibi. Now, the defense is going to give you explanations for why all these things don't look as they do look. It's kind of like if it walks like a duck and it quacks like a duck and it has feathers, it's a duck. The defense is going to try to tell you that the duck in this case is really a donkey, but that's not correct. In this particular case, the people have proved each one of these overt acts, not only because of what the defendant said, but because of the people's own evidence. So you will get a form that will talk about conspiracy, and you will have to decide whether this is a conspiracy to commit murder, whether it's a conspiracy to commit voluntary manslaughter. The people's theory is, of course, that this is a conspiracy. It's an agreement among these defendants to go out and slaughter their parents. This is not a heat of passion killing. This is not a killing with an honest but unreasonable belief in the need to defend. This is a first-degree premeditated slaughter of 2 people. Now, the people's theory of the case is not that the defendant saw money, saw their parents standing in the way of money, and so killed their parents to get the money. That kind of killing, a killing for financial gain, is more appropriate where, for instance, you don't love your spouse too much and you take out $1 million life insurance policy on your spouse. You wait a couple of weeks after the policy is in effect and you kill your spouse. That's a classic murder for financial gain. This is not a classic murder for financial gain. In this case, the motivations in this case are more subtle than that. Now, the judge is going to instruct you that motive need not be proved. In other words, I don't have to prove to you what the motive for the crime was. All I have to prove to you is that this is a premeditated murder and that it's not a murder in the heat of passion or with this honest but unreasonable belief. All right, so motive is not anything anyone has to prove, but motive is also often very helpful because people want to know, jurors want to know, why did these people do this crime? In this particular case, the reason the crime was done was not simply to get money. The reason the crime was done was because the defendant, specifically this defendant and his brother, wanted to maintain their life in the way it was without their parents telling them what to do, without their parents controlling them, without their parents possibly disinheriting them and making them go off on their own. And so if you look at the conduct of Lyle Menendez after he slaughtered his parents, you will see conduct which carries forth that purpose. He didn't want to go to Princeton, so he didn't go back to Princeton. He wanted to be a businessman, so he bought a restaurant. The testimony of Charles Wadlington, his coach, the testimony of Donovan Goudreau, his friend, indicated that he wanted to own a restaurant. Mr. Wadlington said when he coached him at the age of 15 that he talked about wanting to own a restaurant. Mr. Goudreau indicated that they used to go eat at Chuck's Spring Street Cafe, and that Lyle Menendez talked about how it would be a neat place to own. And so what happens? The first thing he does, he goes out and he buys a Rolex watch. He buys a $70,000 Porsche. He buys a restaurant. He buys homes. He emulates his father, but without his father's control. And so to say that this is a murder strictly to get money is to misunderstand the motivation of the defendants. It's a lot more, it's got more components to that than just to say they wanted money. Because if they wanted purely money, there are other ways they could have gone about getting the money. What they wanted was their lifestyle. They wanted freedom. And they wanted to be free from the idea that their father would somehow disinherit them. And pervasive through this case is the notion that in the spring of 1989, Mr. Menendez was not happy with Lyle Menendez. Lyle Menendez had struck a deal with his father that he was going to do better at Princeton, but he didn't. And when he came home from Princeton that summer, the family got a couple of notices about the fact that Lyle had once again not performed up to expectation, that Lyle had gotten in some trouble over a party, and the father was going to have to make some payments because of this party. Lyle Menendez was not even keeping his end of this bargain where his father had reduced his expectations and told him, just pass. I don't expect good grades. I don't expect graduate school. Just pass. Just get through Princeton. And it was beginning to look like he couldn't or wouldn't, and I think wouldn't is probably the better word, even do that. Now, there are two other things that you're going to be asked to do at the end of filling out these verdict forms. You're going to have special circumstances to find. Special circumstances are those things, they're special allegations. And they deal with this particular kind of crime. And there are two special circumstances in this case. And the first one's very easy. It's multiple murder. If you find that one of the murders was a first-degree murder, and the other murder was either first or second degree, then this multiple murder special circumstance should be checked off by you as being true. Now, if you find 2 counts of first-degree murder, that satisfies it as well. But 1 count of first-degree murder and 1 count of second-degree murder means that the defendant should be and has been convicted of multiple murders. The second particular special circumstance deals with murder while lying in wait. Lying in wait, the judge is going to give you a rather lengthy instruction about lying in wait. But basically what it says is, and I'm going to read you part of it right now. For a killing to be perpetrated while lying in wait, both the concealment and a watchful waiting period, as well as the killing, must occur during the same time period or in an uninterrupted attack commencing no later than the moment concealment ends. Now, lying in wait traditionally is thought of as an ambush killing. For instance, I decide I want to kill one of you. I find out where you live. I hide behind a bush. I wait for you to come home. When you come home, I jump out, I get my gun, and I shoot you dead. That is a classic example of murder by lying in wait. I am lying in wait. I'm concealing myself from you. I'm concealing my purpose from you, and I'm taking you from a position of advantage and surprise. But ambush, which that is not the only kind of lying in wait. Ambush is kind of the idea where the victim comes to where the killer is. But in lying in wait in California, the killer can go to where the victim is, and it still constitutes lying in wait. For instance, if you are in a room and the doors are closed and you're minding your own business watching TV and you're taken by surprise by your 2 sons, that satisfies some of the requirements of lying in wait. If there is a clear, and I'm again reading, if there is a clear interruption separating the period of lying in wait from the period during which the killing takes place, so that there is neither an immediate killing nor a continuous flow of the uninterrupted lethal events, the special circumstance is not proved. In other words, if I'm hiding, waiting for you to come home, and I get bored, and I go and I get a cup of coffee, and then I see you, and I see you on the street, and I just go kabam, that's not a lying in wait. A lying in wait means that that the concealment and the unlawful activity is continuous and uninterrupted. Again, I'm reading, a mere concealment of purpose is not sufficient to meet the requirement of concealment set forth in this special circumstance. However, when a defendant intentionally murders another person under circumstances which include a concealment of purpose, a substantial period of watching and waiting for an opportune time to act, and immediately thereafter a surprise attack on an unsuspecting victim from a position of advantage. Those are kind of the crucial words there. The special circumstance of murder while lying in wait has been established. If the murder is done suddenly without a period of waiting, watching, and concealment, the special circumstance of lying in wait is not present. All right, what this is saying to you is that in addition to being a premeditated first-degree murder, that this murder was committed by means of lying in wait. In other words, first you'd have to find that it was a first-degree murder, and then you would have to find that this murder was done by means of lying in wait. Well, in this particular case, if the people's theory is to be believed, and of course I'm going to urge that it should be, these particular requirements have been met. And therefore, this special circumstance, as well as the multiple murder special circumstance, should apply. Now, I'm going to briefly go over with you a few of the standard jury instructions that you're going to get. One of the things the judge tells you is he tells you the different theories of murder and manslaughter. He also tells you things you should do and shouldn't do. He also tells you how to evaluate the witnesses in this case. One thing I'd like to point out to you is once a defendant takes the witness stand, his testimony is governed by the same rules as every other witness. In other words, you should apply the same standards and scrutiny to the testimony of a defendant who's testified in court as to any of the people's witnesses or any of the other witnesses for the defense. They're all witnesses. And the judge is going to give you jury instructions, which I'm not going to read to you, that deal with how you evaluate witnesses. Let me go through these briefly. One of the things the judge will tell you is that neither side is required to call as witnesses all persons who may have been present at any of the events disclosed by the evidence. So keep in mind that there's no legal requirement that all the witnesses who might know anything about this case be called. If that were the fact, we would be here another year. You're also going to get an instruction on prior consistent and inconsistent statements. Prior consistent statements are statements of a witness that were made that are prior to being in court that are consistent with that person's testimony. An example of that would be when you heard the KABC Michael Jackson tape of Grant Walker, where he called in and said, "This is Fred. I was there the day before the homicides. I'm here to tell you that it didn't occur the way you people think." That statement that he gave was essentially consistent with his testimony in court. That is an example of a prior consistent statement. It's an out of court, meaning outside the courtroom statement. And then an inconsistent statement is a statement from outside the courtroom as well. That would be at another hearing or at another time that is inconsistent, that it means different from the witness's testimony. And a classic example of inconsistencies in this case would be the testimony of Judalon Smith. To try to dissect her testimony as to what is consistent and what is inconsistent would require more time than any of us would want to deal with it. But as an example, Ms. Smith took the witness stand, and on several occasions I read to her statements that she had made either in a different courtroom or in an affidavit that she'd filled out. Those statements were sometimes consistent with her testimony and sometimes inconsistent. And at times her testimony here in this courtroom from day to day was either consistent or inconsistent with what she was willing to say at any given time when I was questioning her or when Mr. Burt was. So that's an example. When the attorneys get up and they say, well, isn't it true that on a prior occasion you said blah, 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 and here in court you're saying something different? That is an example of an inconsistent statement. And you can consider those for whatever value you think they serve. The judge is going to read you an instruction called credibility of the witnesses, where he tells you what things to look for. Two of the things I'd like to emphasize is when you're looking at a witness, you look at the existence or non-existence of bias, interest, or other motive. Now, in this particular case, I'd like you to apply this certainly to the defendants because they have a bias, interest, or other motive in testifying. And I think we all know, and I think it's been driven home, that their bias and interest and motive is not to be convicted. I mean, they desperately don't want to be convicted. And the other bias, interest, and motive, I think, goes to the relatives, especially the relatives of the defendants. I think that the relatives were basically sincere when they came forward and talked to you. And I'm not going to stand up here and tell you that they lied because I don't believe that they did. Some of their testimony was exaggerated. Some of it was hard to believe. Marticano, I think, would probably be at one extreme, and Terry and Carlos Baralt would be at the other extreme of the relatives in this case, leaving aside Brian Anderson, who, of course, testified for the prosecution. But I think that their motivation was probably, in their own minds, good, and that is they're here to save the defendants. There is nothing that will bring back Mr. and Mrs. Menendez. And in the minds of the relatives, I can see that it's very logical to assume, well, we can't bring them back, so let's save their sons. And I think that that is a very human emotion. I think for people to feel that way is very understandable. But keep in mind what's been painted for you here is a very dismal and awful picture. And keep in mind that these relatives often sent their children to stay at the Menendez home for more than a day at a time. Some of these people sent their children to stay at the Menendez home for weeks, months, and years at a time. And yet they come into court and they malign the parents as if they were Hitler, that they had sent their children knowingly to a concentration camp where their children and the defendants were treated hideously. What the defense has done is they've taken selective incidences, jumbled them all together, and made it look like the Menendez home was one constant horror. If in fact the Menendez home was one constant horror, then ask yourself why these people who knew about it, because they came in and talked about it, why would they have sent their children there all these different times? What's been attempted here is to paint a very, very negative, awful picture. And I'm not going to stand here and tell you that I wish these people had been my parents. I'm not going to say that they were wonderful, wonderful parents. They obviously had terrific flaws. Most people do. And think about yourself. Think about if someone wanted to paint you in a very bad way. Think about things you've done in your life and take all the little bad things you've done in your life, because everyone's done them, and put them all together without any way to say about anything about the good things. And if you put them all together and you only see bad, then that's the picture that's going to be painted. Obviously, these people were flawed. They loved their children, but they pushed their children. And perhaps they pushed, well, I think it's obvious they pushed their children too far because their children killed them. But to say that these people were the monsters portrayed in this courtroom belies human nature. Human nature being what it is, these relatives who came in here and so maligned the dearly departed when they were alive, they were more than willing to take advantage of their hospitality and their generosity. They were more than willing to spend time with them, to send their children to them. Diane Vandermolen spent a year, I think 13 months during one stretch of her life in the Menendez home. But her mother comes in and says bad things about her sister. And parenthetically mentions the fact that she took clothes out of her sister's closet after her sister died, because after all, they were the same size. So keep in mind that these people, while I'm not going to urge to you that they were liars, they certainly have a bias or interest in this case. The other thing that I'd like to point out that the judge is going to talk to you about is evidence of the existence or non-existence of any fact testified to by the witness. What does that mean? That means when Eric Menendez and Lyle Menendez testify that they went to the Big Five and they were about to purchase handguns and they picked them all out. Well, the fact that the Big Five doesn't carry those handguns is evidence of the non-existence of the fact testified to by the witness. And when Mark Heffernan comes in here last week and says that he gave a tennis lesson to Eric Menendez the morning of August the 18th, the morning when they were allegedly at the Big Five buying the non-existent handguns, that is other evidence of the non-existence of the fact testified to by the defendant. And the court's going to tell you that you can consider those kinds of things in evaluating the evidence. The other thing the court will tell you is that discrepancy in the witness's testimony, or between his testimony and someone else's testimony, do not necessarily mean that the witness should be discredited. If we all went to the same movie, let's say, and afterwards we were all asked to describe the movie, everybody would describe it differently, because that's just human nature. So the question really is not was there a discrepancy in the testimony, and this applies to the defendants as well because they're witnesses, but whether those discrepancies have to do with something major or something that's understandable. The other instruction you're going to give, and this is actually my favorite instruction for being the most confusing, and this is how it starts. You are not bound to decide an issue of fact in accordance with the testimony of a number of witnesses, and it goes on. what this really says is don't count the witnesses. The people in this case presented a far fewer witnesses than the defense. And this instruction tells you that you don't just count up the number of witnesses and decide, well, the defense called 40 or 50 witnesses, the prosecution called 20, the defense wins. That's all this particular instruction says, but it takes a long time to get there. That's fine. That brings me to, yeah. And that particular instruction brings me to the next part of my argument. This is part 2. I only have 3 parts left. These are the prosecution witnesses. I'm going to go with you very briefly through each of the witnesses that were testified in the prosecution's case in chief. Christine Nye was the dispatcher from the Beverly Hills Police Department who testified that she received the phone call from Lyle Menendez. We know it's Lyle Menendez now, in the late evening of August the 20th. Avril Crome was the neighbor who lived 2 doors down from the Menendezes, who testified that she heard what she thought were firecracker noises somewhere after 10 o'clock, between 10 and 10:15 is the best that she could put the time. Now later on, the defense brought in Mrs. Lord, who indicated that she was a neighbor who heard these sounds, and she thinks they were at 10 because she remembers looking at her clock. And for purposes of discussion later, in fairness and to benefit the defense, we will fix the time of the killings at 10 p.m., even though Mrs. Crome said she thought it was a little bit later. Officer Michael Butkus was an officer from the Beverly Hills Police Department who arrived at the scene and observed the demeanor of the defendants. Demeanor was how they were acting. He saw them come out of the house. He saw them act grief-stricken that night. Sergeant Kirk West was the gentleman who came in and testified that he and others went into the house and searched the house. He said he saw rifles upstairs in the closet. He saw no smoke. Remember, smoke is something that keeps coming through this trial. The defendants talked about the smoke when they first talked to Sergeant Edmonds and later on. But Kurt West was here to tell you that when he got there, which was about 3 minutes after the 911 call, there was no smoke in the den. That becomes less important now that we know the defendants did the crime. But let me point out to you something. When the prosecution presents any kind of case, we have to prove 2 things. We have to prove a crime occurred, and we have to prove who did it. And when the defense attorneys stood up an opening statement and they said, well, our clients did the crime, that is not evidence. The people cannot rely on the defense attorney's opening statement to prove their case, just like what I'm saying to you right now is an evidence. So even though it was pretty obvious all through the trial that the defendants weren't going to admit that they did the crime, prosecution still has to prove that they did the crime. We have the burden of proof, and it's fine that the prosecution has the burden of proof. I think it's essential to our system of justice that prosecutors have to prove what they say they can prove. Otherwise, people should not be convicted. That's the system of justice we have here. It is imperfect, but in my opinion, it's the best system of justice. Prosecutors must prove what they say they can prove. And we have to prove it beyond a reasonable doubt. But we also have to prove not only that they committed the crime, but who committed it. So in our case, when we proved that the defendants did it, we weren't doing it to be overbearing. We weren't doing it to be to waste time. We had to prove that. We had to prove that the defendants were the ones who committed the crime. And Dr. Oziel was one of the essential components of proving that they did it. Because if I had proved to you a murder, but I hadn't proved to you who did the murder, then I haven't carried my burden of proof, independent of anything the defense says. The prosecution's entire case, all these witnesses on this page, have to prove the commission of the crime and who did the crime. So when Sergeant West said, well, there wasn't any smoke in the den, that's so I can later on tell you, well, when the defendant keeps talking about smoke in the room, that proves that he was there at the time of the killings not later on. Now, you all knew that he was there because his attorney told you that. But in terms of what I have to prove as an attorney, I have to prove he did it, independent of what his attorneys might have said. Sergeant West also said that when he came in the front door that you could hear the television set from the front door. An interesting point in this case. He said that the lights were on inside of the den, and he also indicated that the lights were on in the guest house and the door was open. Now, recently you heard testimony from Marzi Eisenberg that Lyle Menendez told her a day or two after the murders that he was in the guest house and didn't hear anything. And it's the people's offer to you that that was a contingent alibi. That what he told Marzi Eisenberg was one of the things they had planned to say if, in fact, the police had arrived more speedily than they did. In fact, they didn't arrive at all until the defendant called them. And I'm sure that was sort of a problem for the defendants because then they had to make the phone call. But it's the people's position that that was the contingent alibi, that they went to the guest house. And you'll notice in the photograph, I think it's 397, it was marked later on, that you can see that the guest house is in fact well lit with the door open. Bob Anderson was the gentleman from the shark fishing trip. He indicated that both of the defendants were wearing jackets. He indicated that the family arrived at approximately, and he was very, very general, approximately 4:30 or 4:40, that they left the dock, and he said between 4:30 or 5, and that they returned to the dock between 11:30 and 12 that night. And he described that the defendants were in the front of the boat and their parents weren't with them for most of the trip. Now, the defense interpretation, I'm sure you know, is that they were afraid of their parents. Now, remember the testimony of Lyle Menendez when he said he thought that this boat trip was the parents' way of killing them. That is utterly ridiculous. You saw Mr. Anderson. He indicated there were 2 other people on the boat with him. It's not even reasonable to think that the parents weren't going to kill him there, but it's also not honest on the part of the defendant. A criminalist from the crime lab, Mr. Catalani, came in very briefly, and you probably don't even remember him, and he indicated that there was blood on the sole of Mrs. Menendez's shoe. Well, that seems to indicate that she stepped in blood, and you can draw your own conclusions from that. Sergeant Edmonds testified. Sergeant Edmonds was the gentleman who first talked to the defendants, aside from the officers at the scene. He was the gentleman who was back at the station conducting interviews. And Sergeant Edmonds, we played tape recordings of the statements of both defendants in which both of them were able to get out the story that they had agreed to, which is that they'd gone to the movies, they'd gone to the wine tasting, and then come back to find their deceased parents. Again, it seems that if the defense theory is correct, that these defendants were acting out of fear and fright and that they were almost on automatic pilot like a scared snail, as Dr. Burgess testified, how did they have the state of mind, the presence of mind, to pull it together, to formulate this alibi, to do everything they did after the crime, and then go talk to Sergeant Edmonds, and both of them managed to get through it and say, yeah, this is what happened. And Sergeant Edmonds, with his 32 years of experience, was fooled. Now, the defense is going to argue that that just proves how genuine their grief was. The defense argument is that proves how genuine their acting is. Deputy Van Horn came in. He was the gentleman who brought you the shotgun to show you how the shotgun worked. And he indicated that that particular shotgun, that particular model purchased by the defendants, and Ms. Adams Geyer said the same thing, holds 6 shots. And that in order to have 6 shots in the gun, it normally holds 3, but if you take a plug out of it, it can hold 6. Perry Berman. Now, these are not exactly in order of how the people testified because the computer wouldn't do it the right way. So Perry Berman was the next witness. He was the alibi witness. And when I think the defense is going to characterize Dr. Oziel as being the people's star witness, Dr. Oziel is not the people's star witness. Perry Berman and Amanda Adams Geyer are the people's star witnesses because they establish 2 facts that the defendants cannot escape from. Perry Berman indicated that he left the house on Sunday, August the 20th, at about 10:30 and returned at 1. And at some time during that period of time, he received a phone call from Lyle Menendez on his answer machine. He returned the phone call at approximately 1 p.m. and he talked to Mr. Menendez. Mr. Menendez told Perry Berman that his sons were shopping at the Beverly Center. They seem to shop a lot. They were shopping at the Beverly Center, And Mr. Berman and Mr. Menendez talked about the fact that Mr. Berman wanted Mr. Menendez to help him get a job. He wanted to go into some sort of business dealing tangentially with show business. And Mr. Menendez indicated to him, I'm going on a trip. When I get home, we'll meet. If you were going to kill your sons that night or in the near future, would you make arrangements to meet with one of their friends to help with his future business plans? Wouldn't you say instead, gee, Perry, I'm really sorry. I'd like to help you, but I'm really busy right now. I can't. But what Perry Berman testified to is that Mr. Menendez said, sure, I'm going on a trip. Call me when you get back. Karen Farrell testified that she was supposed to go play bridge with the Menendezes either Friday the 18th or Sunday the 20th. What come over, play bridge and watch us kill our sons, or come over and play bridge and we'll explain to you that our sons have run away and are never coming back? I mean, the conduct of the parents totally belies the story, the lie told by each of these defendants in this case about what happened between August the 15th and August 20th. Before I continue, I'd like to say this. This is not a case about sexual abuse, and sexual abuse is a very hot topic and has been for probably the last 15 years in criminal law. Sexual abuse happens to people. I'm not going to stand here and say that children are not abused. Children are abused a lot in our society. And it is a horrible, horrible crime when a child is abused, especially by a parent, because there are issues relating to parental abuse that are separate and apart from being abused by a stranger. You know, a stranger you can hate. It's hard to hate your parents. And yet, in this particular case, if you believe in the sexual abuse, that doesn't mean that the defendants are not guilty of murder, because they are two separate things. The sexual abuse in this case, whether you believe it or not, was disavowed by both defendants as to why they killed their parents. And it's the people's position that the sexual abuse is here to make the parents look so bad that you don't care that they're dead. That's why the sexual abuse is brought up, because each defendant said, in fact, at the beginning of cross-examination, I said to Lyle Menendez, did you kill your parents because of what they'd done to you before? No. The sexual abuse, the defense will argue, is to explain why they were so afraid and why the events of August 15th through August the 20th are so compelling. But the real thing is the sexual abuse is to portray these people as monsters so that you will not care that they were dead. The same way if a dope dealer, let's say a horrible dope dealer who's selling drugs to children around a schoolhouse, is murdered. Do you really care as much if that person gets killed as if it's an innocent bystander, someone at an ATM machine gets killed? I mean, those are very different things. But in the law, the dope dealer, the person at the ATM machine, the President of the United States, they all have the same right to live. And in this particular case, if Mr. Menendez was a sexual deviant, pervert, child molester, and as a prosecutor, I have very strong feelings about child molesters. If he was a child molester, we would have tried him for it. The district attorney's office has lots of resources available to try child molesters, lots of people who are specially trained in dealing with child molesters. And as a matter of fact, the district attorney's office would have been more than happy to make those allegations true. You see, there's a difference between being an alleged child molester and a convicted child molester. There are people in society right now who are being said to be alleged child molesters, but until that person's brought into court and given the opportunity to test the charges, to present a defense, to cross-examine the witnesses, they are not a convicted child molester until a jury like you says so. We don't execute child molesters in California, and some of you might think that we should. I think there's certain child molesters that I might think that we should execute. But the state doesn't execute child molesters. The state only executes certain kinds of murderers. And until the legislature or the voters through a referendum change the law to execute child molesters, we can't execute them. And these defendants can't execute them either. So keep in mind that although you might believe that Mr. Menendez was a child molester, he was only an alleged child molester. And as a child molester, he had the same rights to present a defense as his son. And he had the right to spend his money to defend himself. And he had the right to hire an attorney or two to defend himself. And he had that right, but that right was taken away from him. So keep in mind that in our country, we have a country of laws, and vigilantism is something that we cannot tolerate. Because then what happens when you say, what if you decide your neighbor's a child molester? And you go kill your neighbor, and no one's ever proved your neighbor's a child molester. And where does it stop? Do you get to start killing all the dope dealers in the neighborhood? We have a system of laws that protect the guilty as well as the not guilty, that protect the petty thief as well as the murderer. And they're all the same kinds of laws. So keep in mind that Mr. Menendez was never a convicted child molester, and that the state would have prosecuted him if the defendants had so desired, but they didn't. Continuing on now with Mr. Berman. Mr. Berman indicated that he called Lyle Menendez back on the telephone between 4 and 5 in the afternoon. Perry Berman did not testify as Lyle Menendez did. Perry Berman did not testify that Mr. Menendez had told him when he talked to Mr. Menendez earlier that Lyle and Eric could not go out that night. He didn't testify to that. He testified that Lyle Menendez told him during the phone call between 4 and 5 that Lyle and Eric were going to see Batman and that they would meet Perry at the Taste of LA at about 9:30. Obviously, they thought they could get the murder accomplished earlier than they actually did. Perry Berman testified he left the Taste of LA at approximately 10 o'clock, that Lyle called him after 11, and we know from the phone records that Lyle called him at 11:07. And Lyle indicated to him that he'd gotten to the Taste of LA at 10:15. This covers him because it takes more than 15 minutes to drive from Beverly Hills to Santa Monica. And so Lyle Menendez is basically saying, I got here at 10:15. I couldn't have been home at 10 when the murders occurred because I was en route. This, of course, is a lie, but this is what he tells Perry Berman. And then if you recall, he called back a second time and tried to get Perry Berman to meet him at the house. And Perry said, no, I don't want to disturb your parents. Remember, Mr. Menendez is going to help him get a job. I don't want to disturb your parents. I'll meet you at the Cheesecake Factory. Donovan Goudreau testified that he was not the one who bought the shotguns. Now, it was very clear from the defense attorney's opening statements that the defendants were going to say that they had purchased the shotguns, which they have to do because we've got the records proving they did. So they can't exactly take the stand and say, well, we didn't buy those shotguns. So they have to admit that they bought the shotguns. But Donovan Goudreau was called to testify because the people have to prove the elements of the crime of murder, premeditated murder, and he said he didn't buy the shotguns. He also indicated that when he moved out of the room at Princeton, his wallet was gone, and that Lyle admired Chuck's Spring Street Cafe, that Lyle didn't have a lot of cash normally. And the other thing that he said that was interesting is that after the homicides, after the murders, Lyle Menendez didn't contact him. Now, we know from this conversation of September the 17th that the detectives told Lyle Menendez in Princeton when he was staying with his family, oh, your friend Donovan Goudreau wants us to send word to you. He's working at Boxer's Restaurant. Now, Lyle Menendez made a great show of the fact that Donovan was his dearest friend, and he was crushed when Donovan had to leave the room, and yet his parents are dead. He's doing exactly what he wants. He's buying the watch, driving the Porsche. He hooks back up with Jamie Pizarczyk, and he doesn't call his dear beloved friend Donovan Goudreau. If in fact Donovan was such a good friend, why didn't he? Especially now that his father was out of the way. Mr. Wenskowski, Richie Wenskowski, he was the gentleman with the rather thick New Jersey accent who testified that he worked as a bodyguard for Lyle Menendez, that Lyle Menendez indicated that the mob or the cartel had killed his parents. He guarded him from either the 28th or 29th of August until September the 6th. Now, Mr. Slotkin testified recently that he had a conference with the two defendants dealing with their lost state. They were lost souls, and oh, by the way, they wanted some money advice. And that this conversation took place within the first 2 weeks of his initial meeting with them on either August the 21st or August the 22nd. That is very hard to do because what happened is the defendants both went back east about the 25th or 26th of August. Lyle Menendez flew home for 1 day by himself to erase the computer, immediately flew back on the 31st of August. And we know from records that he was in Princeton through a period of time, at least to the 8th of September. And we know from Mr. Wenskowski, he guarded him through September the 6th. On the September the 8th, Lyle Menendez is buying condominiums in Princeton, New Jersey, and signing documents. So when was it that Mr. Slotkin saw Lyle and Eric Menendez? I submit to you that he saw them that first week before their parents' funeral, because Lyle Menendez was on the East Coast continuously for 2 weeks, except for the one day when he flew home. Mr. Wenskowski also indicated that Lyle Menendez spent a lot of money, that he bought clothes, a car, townhomes, and he wanted to buy a bulletproof limousine. He also asked Mr. Wenskowski if you could get ballistics off a shotgun shell. I submit to you that when Lyle Menendez went back in the room with his brother to pick up the shotgun shells, he wasn't just worried about fingerprints. He was worried about ballistics as well. He was worried. And remember, Deputy Van Horn talked about the fact that you can match a certain shotgun shell as having come from a particular shotgun. He also indicated that Lyle Menendez called him shortly before his arrest in March of 1990, and Lyle Menendez had flown home with Glenn Stevens and another friend. He called Mr. Wenskowski and said, hey, I understand the Beverly Hills police were at my restaurant, which was at that time changed from Chuck Springs Street Cafe to Mr. Buffalo's. And Mr. Wenskowski says, yeah, they were here. I don't know what they wanted. We know from Lyle Menendez's testimony that during that particular trip back to Los Angeles, he went looking for the guns again. Lyle Menendez knew that the police were on his trail, and he went to look for the guns again after he talked to Mr. Wenskowski and found out that the police had been back at the restaurant. The next witness who testified was Amanda Adams Geyer. Miss Geyer is the lady who sold the shotguns to the defendants. And again, along with Mr. Berman, she is one of the key prosecution witnesses. Now, what she had to say was pretty bland. Yeah, I was there. I filled out some forms. I can't identify them. But what's so significant is that they bought the shotguns 2 days before they slayed their parents. She indicated that when this one person came in, that he had no hesitation. He said, I want 2 of those. And she indicated that the transaction was fairly brief. But we know things from that transaction which are very damaging to the defendants. We know that they used false identification. We know they used a false address. We know they used a false place of birth. And we know that they drove 2 hours to San Diego in order to buy those shotguns. Now, Lyle Menendez's explanation was, well, I just was driving and I'd been to La Jolla before and we just ended up there. What happened is they went to a local gun store, and it probably was the Big Five in Santa Monica, and discovered that in order to buy these guns, you have to fill out a form. The form that you saw in here, it's in evidence now. You have to fill out the form, and once you fill out the form, people are going to know who you are. So rather than fill out a form within 5 or 10 miles of home, you've got to go out of town to fill out that form. And so what happened is they had to leave town, and you know what? It almost worked. If you remember the testimony of Detective Zoller and the testimony of Judalyn Smith, it wasn't until after she went to the police that the police knew to go to San Diego to look for the guns. And as difficult a person as Miss Smith might be, but for her, they wouldn't have known where to go to get the guns. So Dr. Burgess talked a lot about the fact that this was a disorganized crime scene and, that a good murderer would have done it better. But that's not how people behave. And these defendants almost got away with this crime. So keep that in mind when you evaluate Dr. Burgess's testimony. Glenn Stevens was the friend of Lyle Menendez, and I'd like to say something about Mr. Stevens, Mr. Grant Walker, and people like Jamie Pizarczyk. The defense impeached Mr. Stevens with the fact that he exaggerated his resume and he stole money out of a till, and that's something he came forward with. Yeah, I stole money out of the till from the restaurant. Is it so hard to understand that people, that friends or relatives of these defendants might be appalled by what they did? Jamie Pizarczyk, when she found out that Lyle Menendez was in fact responsible for murdering his parents, went out and got a new boyfriend. Well, is killing your parents a really attractive quality in a future mate? It seems to me that people here have their morality and their ethics just jumbled. I mean, slaughtering your parents is a really horrible thing. And when Glenn Stevens said, friendship transcends a lot, it doesn't transcend murder, that should be the correct way to view this particular crime. It is a horrible thing to do to someone. And your friends might forgive you if you drive without a driver's license or cheat on your spouse or do some other thing that people do. But I don't think anyone's friends or relatives need to forgive them or understand or cover for someone when you murder your parents. And these people, these were sucked in by Lyle Menendez, and he portrayed himself as this grieving son. He portrayed himself as potentially being victimized by the mob himself. I mean, he hired a bodyguard, for Christ's sakes. He wanted people to believe that he was next. He wanted people, he not only said, I don't know who did it, but he diverted attention specifically to the mob or the cartel. And then he began to think, ooh, that's not such a hot idea, because maybe the mob will come after me because I've slandered them or I've said that they did something that they didn't do. So he thought better of that position and began to retreat from it. But when Mr. Stevens came and testified in this court, he was cooperating with the police early on because he didn't think that this was a very good thing. He didn't think that Lyle Menendez killing his parents was acceptable. And the defense wants you to believe that he's a horrible person because he snitched off his friend. Well, that just sort of is looking at things the wrong way, because if you had a friend that murdered their parents or their spouse, the appropriate human response is to feel revulsion for that. And if we don't feel revulsion at that kind of violence, then something's wrong. He indicated, Mr. Stevens, that Lyle Menendez told him at the memorial service in Princeton that he'd waited a long time for the position he'd been in. And that is similar to what Marzi Eisenberg testified to when Lyle Menendez said, no, Marzi, you don't understand. These are my father's shoes. Lyle Menendez, in a way, wanted to be like his father, travel in limousines, be a big businessman, wheel and deal like his father. He also indicated, Glenn Stevens did, that Lyle had gone home to look at the computer, that there were 3 things on the computer he looked for: Menendez, list, and will. That directly tracks Mr. Whitkin's testimony. And if you didn't like Mr. Stevens because you thought that he shouldn't have lied on his resume, how about Mr. Whitkin? Mr. Whitkin came in here and talked to you, and Mr. Whitkin there was no reason for that man to lie. He was very believable. So much of what Glenn Stevens has to say is corroborated by the testimony of other witnesses. Mr. Gross came in, and Mr. Gross indicated that the handwriting on the shotgun purchase records was probably, he couldn't say definitely, Eric Menendez's. Again, it might have seemed silly to you that we called him, but we had to prove it independently of what the defense attorney said. Mr. Whitkin indicated that the computer was erased on August the 31st, that he was asked to look for Lyle, Eric, Will, and Menendez. And he indicated something interesting. He said that it made his spine crawl when Lyle asked him to make it look like he hadn't been there. And Mr. Whitkin testified that at the time that Lyle Menendez made that request of him, he didn't know there'd been a murder in the house because he doesn't read the Metro section. And so I think that's an interesting observation from someone who was actually there. You see, we come into court and we all get dressed up, and everybody's very civilized, and the courtroom's paneled and carpeted, and there's the judge wears a certain kind of robe which judges for centuries have worn, and everything is very civilized. And we show you pictures because we're not going to bring in blood and gore. But remember that what happened on the night of August the 20th was very different from what happens in a courtroom. And this is a 2-dimensional picture of blood and gore. You can't even smell what this must have smelled like either. You can't sense what this must have felt like. Mr. Whitkin was not there during this period of time, but Mr. Whitkin was there on August the 31st, and he said that Lyle Menendez made his spine crawl, and he didn't even know there'd been a murder in the house. Mary Ellen Mahar was the lady from Slavic's Jewelry who indicated that approximately $15,000 worth of Rolex watches and money clips were purchased on August 24th. Now, I, like many women, like to shop to relieve stress, or shop for entertainment, or shop just to shop. But shopping to get over killing your parents seems to be taking shopping a bit far. On August the 24th, Lyle Menendez went out and bought a watch. And Ms. Mahar testified that he called up somebody named Carlos, or I'm not sure she said Carlos, so don't quote me. She called up and and he was talking about the propriety or the way it would look to wear the Rolex to the funeral. Well, we know he did wear the Rolex to the funeral in Princeton. So even though it was something his father didn't really approve of, he went ahead and he bought it and he wore it. And it was a version of telling his father where to go. You also heard from Dr. Golden, who was the coroner's representative, and I'll go through what he said a little later. You heard from Dr. Oziel. Now, Dr. Oziel, I think the defense proved beyond any possible doubt that Dr. Oziel was a philanderer. He cheated on his wife. They proved that. Absolutely. They did not prove that he can't work a tape recorder. And ultimately, all the bad things said about Dr. Oziel, all the horrible things, I mean, this was a trial. The defense really tried Dr. Oziel for his crimes and misdemeanors. And in the end, when you hear the December 11th tape, who cares? Because how hard does it, I mean, what kind of person do you have to be to run a tape recorder? Dr. Oziel testified to prove identity. He was here to prove that these defendants and not somebody else did the crime. And the defense spent a great deal of time trying to discredit Dr. Oziel, and part of that was done because they had the ammunition to do it. There have been presidents of the United States who've had girlfriends, and they were not crucified as badly as Dr. Oziel. But Dr. Oziel sat there for days, and he took it. And they brought in Judalon Smith, and whatever you think of her, she was obviously his girlfriend at one point. And that was all done so you would lose sight of the evidence. The defense doesn't want you to remember this. They want you to think about that horrible Dr. Oziel. They want you to think about Glenn Stevens cheating on his resume. They want you to think about Judalon Smith as the woman scorned. They want you to think about Dr. Burgess and her theory about snails. They want you to think about anything but this picture. Now, I've only put up one exhibit here because this is not a complicated case. This is a very straightforward case. We only called this many witnesses. This is not a hard case at all. This is what happened. These two people were sitting there watching television, and they got slaughtered by their sons. We proved that they bought the guns on August the 18th. We proved that Perry Berman was called to set up an alibi. There are other things that I'm going to discuss later on in my argument to prove that the defendants lied to you in this courtroom from the witness stand, but we know they lied every chance they got. This one picture is all you need. This and the other evidence that people presented proves that this is a premeditated first-degree murder. It was done through conspiracy. It was done by lying in wait. So all this other stuff, Dr. Oziel, I mean, if I were a defense attorney and the prosecution called Dr. Oziel, I'd be jumping up and down because you've got Judalon Smith, you've got Cindy McPhee, you've got Pamela Bozanich to come in and say bad things about him. But in the end, listen to Lyle Menendez's words on the December 11th tape, and it doesn't matter who Dr. Oziel was sleeping with. Dr. Lulo and Brad Brunon came in. Dr. Lulo was the psychologist, and I would say that we've had enough psychologists in this case to sink a ship. But Dr. Lulo came in and said, I talked to Dr. Oziel on Halloween. I remember it was Halloween. I told him to make tapes. I told him to make notes, not tapes. Told him to make notes, put them in a safe place. Tell your client, patient, that you've done this. Mr. Brunon, who was his attorney, came in and gave him and said that he'd given him essentially the same advice. Detective Zoller was called and several times during the trial because as the investigator, he has little bits and pieces here and there. But some of the things he told you were that the defendants wanted to get into the room on August the 21st. Remember, they came at 5:30 and they wanted to get back into the crime scene. Now, it's interesting to note that when Sergeant Edmonds was talking to Lyle Menendez, he explains, we don't want you going into the crime scene because you might disturb some evidence. And Lyle Menendez is thinking, oh gosh, what if I left something? So he goes back and says, hey, we need to get tennis equipment in that room. And if you look at the photographs of the room, you'll see there's tennis equipment everywhere. But it's Sergeant Edmonds who probably tipped him off that he might want to go back. We also know from Detective Zoller and from Lyle Menendez himself that he went back and went through the car. And in front of the police, he took evidence out of the car which might have incriminated him. That is pretty cool. I mean, to be able to kill your parents, go talk to the police, go back to the scene of the crime in view of a police officer, go through your car, take some shells, put them in your pocket, walk off. That takes an amazing amount of cool. And if, in fact, the defense theory is correct that he was acting out of fear and he was just all upset, that doesn't go along with this idea that he went back to the scene of the crime. You know that statement that the killer or the criminal always returns to the scene of the crime? Well, he comes back and he removes evidence in front of the police. I would think that most people would just cross their fingers and hope that the police didn't look in the car. Detective Zoller also indicated he was here to talk about the statement of September 17th, and there's only one portion of it which I'd like to highlight, and I'll do it now. In the September 17th statement, Lyle Menendez talks about the camcorder, and that is important in light of the testimony of Mr. Anderson. Mr. Anderson indicated that Jose Menendez was going to have a talk with him Jose was in Kalamazoo with his son Eric. He wanted to talk to Lyle about the camcorder that had recently been purchased. Now here's the statement from September 17th. Zoller says, now one statement I heard, and I don't know who it was from, you had gone out, bought like a video recorder, a camera. Lyle Menendez says, yeah. And your dad said, gee, that's nice that he could buy something like that. I wonder how he could pay for it. And Lyle Menendez says, yeah, he said that. But Mr. Detective Zoller says, did he end up paying for it? Lyle says, he ended up paying for it, sure. I mean, it's one of those things where if I knew we needed it and I knew that he thought it was a good idea, he wouldn't buy it himself ever. But I'd buy it. And then, we just discuss it and he'd buy it and he'd pay for it. Or if it came down to it, I could pay for it. Detective Zoller says, uh-huh. Lyle Menendez says, my father forever, unintelligible, but trying to teach us the value of money, and unintelligible, but there were lots of fights. The motive for the murders is that these defendants were starting to get into a great deal of trouble with their parents. Eric Menendez testified that his father had disinherited him and was going to disown him in the spring of 1989. We know that shortly before their murders that Mr. Menendez wanted to talk to his son about this camcorder. Lyle Menendez admits in the September 17th statement that there were lots of fights. The father was trying to teach him the value of money. When Lyle Menendez goes back to California on August the 31st to erase the will, it's not because he thinks his cousin Carlos is going to do something fishy with the will. It's because the family had already found the two wills that had been executed in 1980 where both of the defendants would inherit. And any subsequent wills would never help this particular defendant. Detective Zoller also indicated that he recovered the information about Howard Witkin in early December of '89. That's how he found Howard Witkin. And also testified about a service of a search warrant on Dr. Oziel, where some tapes were recovered. I'd like to reemphasize again that if you believe that Mr. Menendez was a child molester, that does not mean that these defendants committed voluntary manslaughter. In order for them to be guilty of voluntary manslaughter, they have to actually have killed in the heat of passion or in the unreasonable belief in the need of self-defense. Mr. Menendez, if he were a child molester, had a right to have an attorney. He had the right to a jury trial. He had the right to a fair and impartial jury. He had the right to confront and cross-examine the witnesses against him, which means he had the right to sit in the courtroom, look at his sons, and have them questioned by his attorneys to test the validity of their allegations. He had the right to testify if he wanted to. He had the right to take the stand and say, I didn't do those things, and let me tell you why, or I was out of town, or to present an alibi if he so desired. He had the right to present a full defense and call his own expert witnesses. He could have paraded 3 or 4 or 5 or 6 psychologists in here to explain him and his actions or his son. And he had the right to spend his own money doing it. So I'd like to reemphasize that just because the defense has said that he is a child molester, he's not a convicted child molester. And we in California do not execute child molesters. Now, the next part of my argument deals with the defense case. All right, the first group of witnesses, and I'm not going to talk about each one of these except some of them generically. Family, friends. The two, Tracy Baker was the young woman who came in and said that Kitty Menendez was nasty to her and pushed her onto the sofa because she admitted that she'd been sleeping with Lyle. Sleeping was a euphemism for having sex with Lyle Menendez in Kitty Menendez's house. And yet this horrifying, horrible, awful experience did not prevent her from calling up and asking for concert tickets later on from Mr. Menendez. The other witness called by the defense was Edward Fenno, and Mr. Fenno tried to paint a particular picture of the victims, but in doing so, he also indicated that the defendants lied a lot to their parents and that they gave detailed lies, not general lies, but detailed lies. Well, in this particular courtroom, you heard very detailed accounts given by both Lyle Menendez and his brother Eric. But Mr. Fenno indicates that before they were even charged with murder, before they murdered their parents, they gave detailed lies, and they knew how to do it. The other thing is that Mr. Fenno backed away from a statement he had made, and I impeached him with a prior inconsistent statement from Detective Zoller at the end of the trial. Mr. Fenno said originally that Jose Menendez was very excited about Eric going to Berkeley. Well, that's really significant because if you want to have sex with your son, you want him in the same town. And so that particular statement that Mr. Menendez was excited about Eric going to Berkeley is circumstantial evidence that Eric Menendez was not being sexually abused by his father. Another interesting thing that came out late in the trial is Marzi Eisenberg testified that when Mr. Menendez and Eric Menendez first came to California, when Mr. Menendez was first working at Live, he was out here for several months where Mrs. Menendez was not permanently residing here. She was flying back and forth. And on many occasions, Marzi Eisenberg had to pick Eric Menendez up in high school and take him somewhere. Eric Menendez testified that for the first 3.5 months in California, there was no sex with his father. Well, it's interesting to note that if the mother was not even in town, if Mr. Menendez was having sex with the son, wouldn't the opportune time to be is when they're alone in this condominium at the Oakwood Apartments? Another piece of circumstantial evidence that this abuse is totally fabricated. Relatives, Marta Cano. Marta Cano, interestingly indicated, and I realize that this is a very long process and that it's hard to sit here and listen to this, but I'm going to try to keep my comments. Usually I would argue 2 days on a case like this, and I'm trying to keep my comments to way under that. So please bear with me. Marta Cano was the aunt of the defendants who flew into town, immediately went to Live Entertainment, and began to look for Jose Menendez's assets. That is an interesting reaction to grief. She indicated she spent Tuesday, Wednesday, and Thursday after she got here looking for his assets. She also indicated in a rare moment of candor that she would lie even for me. I asked her about lying, and she said, well, heck, I'd do the same for you. She was talking about telling a lie to Jose Menendez about an accident that Kitty Menendez had had. Mrs. Cano was fairly well impeached. But again, her motivation may be, I can't do anything for my brother. I'm going to help his sons. She also indicates that the defendants told her that they didn't think they were in the will. But from the testimony of Carlos Baralt, we know that the will was found early in the week. And her conversation with the defendants wasn't until Wednesday or Thursday, and more likely on Thursday. And she was impeached with a prior statement about the fact that it had been on Thursday and not Wednesday, which is interesting because if the watches are bought in the afternoon of Thursday, the 24th, what money did Lyle Menendez think he was using to pay for those watches? You see, the will had been found before they went watch shopping. He knew that everything was okay. He knew that the will left things to he and his brother. Then he meets with Marta Cano later that night and pretends on the night of the 24th, oh, well, we're not in the will. He knew he was in the will. He just didn't want to look greedy to his relatives. Also, interestingly, Marta Cano was not present at Live Entertainment when Roger Smith had the talk with the defendants about the $5 million policy. Now, there's been a lot of dispute about the $5 million policy. Much to the defendant's chagrin, Mart Slotkin came in here last week and indicated that these defendants talked to him in this 2-week period, which couldn't have been during that 2 weeks, it was during the first week. These defendants talked to him about this $4 or $5 million that they were going to get from the company. Well, we know that's not the sale of the house. We know that's not stock options. It was an insurance policy that they thought they were going to get. So Marta Cano wasn't even in on that discussion. And remember in the discussion, Roger Smith says that Eric Menendez said, well, what about the insurance policy in favor of the company? And that was the $15 million policy. Eric Menendez knew full well and good that there was a lot of money at stake. And unlike the whimpering, whining, crying creature he wants you to think he is, at the meeting with Roger Smith, he was more than willing to stand up and say, what about the policy in favor of the company? And these defendants didn't do this crime for anything but fear. That's what they want you to believe. Carlos Baralt and his wife, Terry Baralt, came in and probably gave the most accurate portrayal of the Menendez parents that was given in this case. They said bad things about them and good things about them. And I think that their portrayal of the family and the Menendez parents is probably the closest to accurate that you got in this case. Mr. Baralt indicated that the will was found on Tuesday. That would have been the 22nd of August. And that was the will, which is in evidence. And you'll see the two wills. They're pretty standard. Mr. Menendez dies, it goes to Mrs. Menendez. Mrs. Menendez dies, it goes to Mr. Menendez. If they both die, it goes to the sons. It's a fairly standard way of leaving your estate. Pat Anderson indicated that she was present in Kalamazoo when Eric talked back to his father on the tennis court, something that Brian Anderson testified to himself. Diane Vandermolen indicated that she stayed at this horrible, horrible home a lot. And I'd like to ask you, think to yourself, if this was such a horrible place to be, why did she keep going back? Why did she live there for summer after year after year? She also indicated that Lyle Menendez had made what we call a fresh complaint about sexual molestation to her. But interestingly, this fresh complaint was not made to her until the second or third interview with the defense attorneys and until after the third visit with Lyle Menendez at the county jail. And you'll see the slips that show that she went to visit him in the county jail. It's very suspicious that this particular fact was not even brought forth until after she'd been interviewed by the defense investigators 2 or 3 times. Joan Vandermolen was the sister to come in who said that Kitty Menendez, part of why she was here is to say that Kitty Menendez was very secretive, that she hid things from her family. But we know that Mrs. Menendez talked to her brother Brian because Brian was the one she was closest to. We also know from Joan Vandermolen that somewhat like a vulture, she went into her sister's closet and took her clothes because after all, they were the same size. Then we have the expert witnesses. I could spend 2 days talking to you about the expert witnesses. Dr. Briere was the generic child abuse person. He was here to tell you how you should look at the evidence. Dr. Burgess was here. She was here to use crime scene analysis, which detectives used in order to figure out who did a crime. She was here to use that in a bastardized form to get you to understand the defendant's state of mind. Those particular analysis that are done by the FBI are done to help investigators like Detective Zoller look at a crime scene and try to figure out who would have done it. It was not formulated for people like Dr. Burgess to come in here as a hired gun and to tell you that from the crime scene you can tell certain things about what happened. She described this as a disorganized crime scene, and yet by her own definition it was a mixed crime scene because there were certain features of it that showed pre-planning. But the thing that she wouldn't get off of and the thing that she was going to stick to her guns no matter what was that because the defendants got caught, this was a disorganized crime scene. Where there are lots of people in county jail and in state prison who plan their murders, but because of things that they couldn't foresee or because of things that happened either before or after the crime, they got caught. Just because you get caught didn't mean that you didn't plan it. And that is such a simple thing, and yet she wouldn't admit it. And the reason she wouldn't admit it is that she's paid to be a witness for the defense. She is paid to come in here and say what she said. And she was very sweet and nice about not budging from her position. But the fact that she wouldn't give 1 inch shows you how incredibly biased she was. And to say that because the defendants didn't plan out the crime scene so as not to get caught shows that they didn't plan at all is ridiculous. And I use the example of a wedding where you plan a wedding and you plan it and you go get the license, you hire the caterer, you hire the minister, you hire all these people, and the day of the wedding comes and it just is a disaster. Things don't go the way it's planned. I had a wedding like that. You plan it, and then everything just goes wrong. It doesn't mean you didn't want to get married. It doesn't mean you didn't plan it. It means that things just happened. And if it starts to rain on an outdoor wedding and you didn't think it was going to rain because it never rains in that month, but it rains, what do? Well, that's poor planning. But you still intended to get married. You premeditatedly went out and you got the ring and you got the license and you had the caterer. It's just that things happened that you didn't plan for. Well, in this particular case, think about the fact that these defendants almost got away with this crime. But for Julian Smith, and I hate to give her that much credit, but I think that she probably deserves it, but for her going to the police to get her boyfriend in trouble, and oh, by the way, there's this murder I know about, but he's a rapist and he's a horrible man and I want you to arrest him. But for her going to the police, it's doubtful they'd be here. So Dr. Burgess may go on and on about this imperfect crime scene in her ivory tower analysis, but in real life, they were at liberty for 7 months before they were arrested. Dr. Hart talked about psychological abuse. where does bad parenting turn into psychological abuse? I think that's an interesting question. Were they psychologically abused? Well, if you take everything that has been given to you and you look at it in a vacuum, because this is a vacuum. This courtroom is a vacuum. It's not real life. You didn't live in their house. You didn't see the murder. Yeah, you could say that these particular acts would constitute psychological abuse if you exaggerated them, if you blow them out of proportion. And yet, psychological abuse cannot justify murder. It just can't. Now, you may not think you like the Menendez parents. You may think they were bad parents. It does not justify murder. We don't execute people in the state for being bad parents. If we did, there'd be a lot of people dead. Dr. Connie came in here, and Dr. Connie was here twice. He was here once to talk about Lyle Menendez, and he was here once to talk about the December 11th tape. He was here to explain it away because it's an extremely damaging piece of evidence. And so he came back specifically to talk about that tape. Dr. Conti was very clever, and Dr. Conti knows about a lot about child abuse and child neglect. But think about your impressions of Dr. Conti. Think about how you felt about what he was saying. And no matter what was thrown at him, there was not one question I could give him that he didn't have some psychobabble answer for. And that's what he's paid to do. And at one point he said, I wouldn't put my reputation on the line for this case. And I'm just thinking to myself, Dr. Connie, the way you've done in cross-examination, you're going to be in demand all over this country. This is seed money for future venture capital for Dr. Connie, because now everybody who looks like they have a hopeless defense and they can't make it, call up Dr. Connie, get him to come in. In the face of overwhelming evidence of premeditation, he can stick to his guns and he can answer the questions. He doesn't crumble in light of the obvious. So think about Dr. Conti and think about the questions I asked him and the evidence I threw at him, and he was very good at throwing it back. But just because somebody is good at throwing it back doesn't mean it's correct. And then we had Dr. English. He was the gentleman who came in and said that he'd done an examination of the defendants and found no indication of child sexual abuse. And that was all he had to say. These particular doctors here, I'm not going to say Dr. English is one because he's not a psychologist. But notice, first of all, Hart, Conti, and Burgess are all from out of state. They couldn't find anybody in Southern California who knows something about child abuse. I mean, there have been child abuse cases in Southern California in the last 15 years. Dr. Briere, of course, the only local guy, never examined the defendants. He was just here so that you would view the evidence in a certain way. But these three people, and Dr. Burgess especially, these are spin doctors. These are people who are here to put a spin on things to make it look different from what it really is. They're here to tell you how to think. And they have been paid a lot of money to tell you how to think. Now, they've been paid more than $5 a day. But they haven't been sitting in this courtroom like you have watching the evidence. They come in, they take the stand. I'm an expert. I have a PhD. A PhD is a doctor of philosophy, ladies and gentlemen. A PhD is not a medical doctor. They're doctors of philosophy. And they come in here and they say, well, I went to school a lot and I write lots of papers and I get quoted a lot and I quote my friends here and we all quote each other and this is what we think this all means. Well, you don't need these people to tell you how to think. You've been here and spent more time on this case than any of these experts have. You've seen the evidence tested in this courtroom. You've seen cross-examination. You don't need these people to tell you how to view the evidence. Now, the defense is going to make a big deal about the fact that the people didn't call any expert witnesses. Why would you call an expert witness in this case when these people did what they did on the witness stand? Why would you dignify these people's existence as experts by saying, yeah, we think these experts really had something to say, and so we're going to bring our own experts? I'm sure that there are experts on either side, as you well know. But these people that came in here, leaving aside Dr. English, came in here as hired guns for the defendants and nothing more. And they used their years of research and their PhDs and everything else to try to persuade you that you, as common citizens, can't understand the evidence. And that's what they were here for. And for us to call an expert to say, well, this is what it all means, is sort of an insult. Because you've been sitting here watching the evidence. You know what it looks like. You don't need these people who've spent most of their time in academia, most of their time writing papers. You don't need these people to tell you how to think. Right. I'm going to finish these witnesses before lunch. Very briefly, the anti-Oziel witnesses, I think that's a fairly good way of classifying these three people. They were here to say bad things about Dr. Oziel. None of them could prove to you that he doesn't know how to work a tape recorder. Then we have what I call teachers coaches, and I think that there were enough teachers and coaches here to choke a horse. Mr. Mosner was here. He was a soccer coach. Mr. Klaus was a tennis coach. Mr. Curtin was a tennis coach. Ms. Geisler worked at the country club in 80 and 81 when Mrs. Menendez would throw her children on the mercy of the country club and drive off for the day. Sandy Sharp was the thing that she said that really struck me as being incredibly catty is that Mrs. Menendez always needed a bleach job. I mean, the woman is dead. I mean, that's what she said. She needed a bleach job. Alicia Hertz came in and she said that she was a friend of the family and also taught them at school. And she said that she saw Mrs. Menendez in August of 1989 and that she was acting unusually. She also indicated that Mrs. Menendez was going to Quito, Peru, and she found that very unusual. Well, it turns out that Mrs. Menendez has relatives in Quito, Ecuador, and so that whole thing is a big non-issue. Mr. Wadlington came in, and the one thing that I think you should recall about his testimony is that he said Lyle Menendez told him he always wanted to open a restaurant. Well, we know that in late 89 or early 90, Lyle Menendez bought a restaurant with his dead father's money. The neighbors I've already discussed, as I said, for purposes of our discussion, we're going to assume that the killings occurred at about 10 o'clock at night because that gives the benefit of the doubt to the defendants. But the interesting thing about the neighbors is the neighbors heard these noises, and I believe Mrs. Lord either lives on another street or way down the street, and they heard these noises. And yet Mr. Slotkin was brought in to talk about the fact that you can't hear noises within the house. Lyle Menendez testified that on one of the nights he was inside the guest house and he heard screaming and yelling coming from the main house. And yet, so do these people establish, these neighbors show that you can hear noise outside the house, and Mr. Slotkin is supposed to say you can't hear noise inside the house? Or, I mean, it seems to be a conflict in the defense testimony. If you can hear the noise from the shotguns, but you can't hear the noise from the shotguns. I mean, so if you contrast these neighbors with Mr. Slotkin, one of the reasons he was here is to say the maid wouldn't have been able to hear anything. And yet Lyle Menendez said he could hear screaming when he was inside the guest house, and his mother and Eric were inside the main house. Mr. Lowe. Well, Mr. Lowe, remember, he was the man who took Mamie Van Doren to the hotel, and he's not here for publicity, and he testified to the vicious, awful pinching incident. If you look at what happened to these defendants during the course of their life, it's the kind of stuff that would make you mad. Both the defendants were very careful to say, I wasn't angry, I wasn't angry, I wasn't angry. But when Skippy Lowe comes in and he talks about the pinching incident, if I were an adult sitting at a dinner table all dressed up and my father pinched me, I'd be darn mad at him. But I think Mr. Lowe also wins the award in this trial for the most self-interested witness. And I don't think his testimony meant much, except it was somewhat amusing. Mary Dominguez indicated she found pornography inside of the house. We know the house had been rented on several occasions by several people. She's the only witness to testify to this particular pornography, aside from the defendants, whose credibility is almost nil. Mr. Goudreau was here to testify for the defense as to a statement he says, well, a statement the defendant says he told him in a restaurant in Princeton in the spring of 1989. But Mr. Goudreau also was very confused about the source of his information. He indicated he didn't hear that from Lyle Menendez, but had been in contact with a reporter and had talked to people about allegations of child abuse. Mr. Lopez was the gentleman who was the investigator who went to the Big Five after the bomb was dropped during Eric Menendez's cross-examination. Eric Menendez, you can't have bought a handgun, or you couldn't have tried to buy a handgun at Big Five, because if you had, you couldn't have bought one because they didn't have them. So Mr. Lopez was brought in to try to fix it. You know, the old saying, if you can't fix it, feature it. So instead of waiting for us to put on evidence to show that they didn't carry it, Mr. Lopez came in and he had all the pictures and everything. But the one thing that was notable about Mr. Lopez, he was never asked by the defense to find the clerk that the defendants had the conversation with on August the 18th, allegedly at the Big Five in Santa Monica. He was asked to take pictures and describe the shotguns and describe the case, He was never asked to find that one witness, and that was an interesting thing. Mr. Nickel had worked there. That was, again, a preemptive strike by the defense to try to diffuse the effect of this bombshell. Ms. Erdely came in to talk about the alibi, what I call the alibi route. And that is the route that the defendants took after the murders in order to cover their tracks, create an alibi, and get rid of evidence. Ultimately, the difference between her driving time and the people's driving time is 1 minute. So for the benefit of my argument after lunch, let's say it took 50 minutes, like Ms. Erdely said, to drive all the places the defendants said they drove. The activity time, of course, is different. She substituted her own time periods for how long everything took. Mr. Smith came in and testified that he hated Jose Menendez, and I told you earlier about the conversation with the defendants on approximately Tuesday, the 22nd of December, wherein the $5 million policy was discussed. Dr. Cox was the gentleman who saw Mrs. Menendez for 12 one-hour sessions alone and had some pretty nasty things to say about her. And I asked him, Dr. Cox, what is the appropriate way for a woman to react and to act when she finds out her husband's been cheating on her for a third of their marriage? And he didn't have a very good response for that. Dr. Emery is the doctor who prescribed medication for Kitty Menendez, which is interesting, and we don't dispute that she took medication, but it's pretty clear, both from the coroner and also from the testimony of the defendants, that she wasn't taking medication at the time of her death or in the months preceding her death. And then that brings us to the defendants, and I will address that after lunch.
All right, we'll recess until 1:30, ladies and gentlemen. Our coffee at 1:30. A little earlier than that, don't discuss the matter with anyone. Don't form any final opinions about it. We'll see you all back here so we can start promptly at 1:30. Argument of the district attorney.
Thank you. It's always been my feeling that in civilized countries, they give you 2 hours after lunch for a nap, like in Italy. But unfortunately, we don't do that in this country. This is the hardest time for any attorney to argue because everybody's just had lunch. And so please, I understand if you are a little drowsy, and I'm going to be done in under an hour. I'm going to briefly go through the witnesses who were presented in rebuttal. And although you just heard from them, and they're probably the easiest ones for you to remember, they made some points which I think are significant. The people presented Mr. Grant Walker. Mr. Walker was the spa repairman who said that he saw the defendants playing tennis at their home on Saturday, the 19th of August. The reason he's important is because it's the testimony of the defendants that they were out buying ammunition on that date and that they stayed away from the home until approximately 4 o'clock, when they could no longer keep away, and they came home hoping they would miss their parents because their parents were going to go on this fishing trip. And of course, we know that they did go on the trip. Now, a lot of the defense rebuttal case was spent trying to discredit Mr. Walker. Mr. Walker is a guy who cleans and repairs pools and spas. And the defense wants you to believe that he's a publicity hound, that he's got an axe to grind. But it seems that the only axe that he has to grind is that he's offended by what's going on here. And he indicated when he called up Michael Jackson and he used the name Fred. And if you listen to the tape, you'll notice that Michael Jackson calls him Fred. Well, it seems to me that if he was trying to garner publicity for himself, he would have used his name and perhaps given himself a plug. And so it seems to me that whoever might have heard him on Michael Jackson would have a tough time calling up Fred the pool man to come in. But Mr. Walker said something really significant, and I know there are a couple of you jurors who don't understand what he meant when he said this. But he said, I remember where I was when I heard that President Kennedy had been shot. And that was very significant because for those of us who remember the fact of hearing of President Kennedy being shot, you remember exactly where you were. You remember who was around you. You might not remember what color shoes you had on, but you remember that day. It was a very significant day in the history of this country. And when Mr. Walker said, hey, I remember where I was when I heard President Kennedy was shot, and he made a comparison that this was similar to him in its shocking value. He was very genuine in his testimony. And the reason the defense spent so much time in their rebuttal case trying to discredit him is because his testimony is very damaging. It's interesting to note that the defense called Mr. Heffernan as a witness, and Mr. Heffernan damaged the defense just as much as Mr. Walker. But since they called him, it was kind of hard for them to say, well, we called him, but we think he's a big liar or he's a publicity hound or something like that. But just like Mr. Walker, Mr. Heffernan punched a big hole in the defense case because he had testified on another occasion, not in front of you, but it was brought out that he testified in August that Eric Menendez had a tennis lesson on August the 18th. And the way he could pin it down is that Eric Menendez said he was going on a boat trip the next day, and Mr. Heffernan was pretty clear about that. Now, he tried to back away from that statement here in front of you, but when impeached by Mr. Kuriyama, it's clear that in August in this courtroom, Mr. Heffernan testified that the way he knows he gave that lesson on the 18th and not the day before is because Eric Menendez said, I can't see you tomorrow, we're going on a fishing trip and I'll call you later. So Mr. Walker came in, Mr. Walker, who the defense wants you to believe is this publicity hound, whose wife may have combed his hair in the hallway. And I submit to you that almost everybody who would take the stand in this case would probably comb their hair before they took the stand. That's just human nature. It doesn't mean that you're a publicity hound. Mr. Bartek came in to substantiate the fact that he had in fact sent Mr. Walker to the Menendez home to repair the spa. And Mr. Bartek and Mr. Walker are just two working guys. They're just regular old people. They have no axe to grind. They just came into court. Mr. Walker, it seems, because he was offended by what he knew about the case and what he knew from his own personal knowledge about the events of the 19th of August. Then Ms. Pizarczyk. Now, I'm sure the defense has a lot of bad things to say about Jamie Pizarczyk. Again, I'd like to reiterate that I don't know that it's that unreasonable for a young woman to take offense at the fact that her boyfriend is a murderer. I mean, I just really don't think that having a boyfriend who's a murderer is a desirable quality in a mate. And although there are many murderers who do have mates, I'm sure many women would consider a man who's murdered his parents to be someone you don't want to be engaged to anymore. The interesting thing about Ms. Pizarczyk is that the defense is going to attack her credibility. And yet, in the area where she hurts the defendant the most, he admitted she was telling the truth. And that is the bribe that was offered to her. She was offered a bribe, and the tape recording is her statement of what happened. Lyle Menendez asked her if she would take the stand and testify similarly to a scene out of a movie. And once again, a lot of what Lyle Menendez talked about, he talked about The Godfather during his testimony too. When I asked him about going to visit the mafia in New York, how did you know it was the mafia? Was it like the movie The Godfather? Yeah, that's right. He asked Jamie Pizarczyk to replicate or to describe a scene from a movie called At Close Range, in which a man sexually assaults his son's girlfriend. And she said, no, I won't do it I won't do it. And it was indicated to her that money would be paid to her, and she said no. Now, it seems to me that would be a small lie for her to tell to help out her boyfriend. And if she's a money grubber, as the defense is going to portray her, then it seems to me that that would be an easy way to make money. I think there's another way to look at Ms. Pizarczyk. Ms. Pizarczyk, I think, genuinely loved Lyle Menendez, and the defense is going to say she loved him for his money. But the whole time she was with him, she was working. And when they bring in her work schedules and you look at all the days that she worked as a waitress in that restaurant, while her boyfriend was flying back and forth from coast to coast and occasionally attending class at Princeton University, you wonder who was the one who was working hard and who was the one who was a privileged, spoiled brat. So Ms. Pizarczyk is going to be attacked by the defense, but when it comes to the issue of whether or not she was offered a bribe to lie in this courtroom, she said, no, I won't do it. And Lyle Menendez admitted during direct examination that, in fact, he had made that offer to her, and that she's telling the truth about that fact. The other thing that Ms. Pizarczyk told you was that the thing about the hairpiece, that she'd had a conversation with Eric Menendez in his bedroom that she specifically recalls, and he indicated that he knew his brother wore a hairpiece. The defense, believing that they'd struck gold, produced her work records, and she said, well, I think it was when I saw Hurley Burley. We've entered into a stipulation that the play Hurley Burley occurred in November, December of 88 and January of 89. The fact that Ms. Pizarczyk made a mistake about when this conversation occurs is something that's pretty understandable. She indicated, and Lyle Menendez himself indicated, that she was flying back and forth all the time. And I think Ed Fenno also testified that Ms. Pizarczyk was often at the Menendez home and then gone again. So it's not surprising that she wouldn't be able to remember exactly when this conversation occurred. And if you had had a conversation in your life with someone that at the time was not significant, and then later on you found out that it could be significant, and this thing about the hairpiece is obviously now significant, you might have a difficult time pinning it down too, especially if you travel a lot and knew that you'd been in California on several occasions but didn't know when. So for the defense attorneys to jump up and down and get excited about the fact that she was working in March of '89, I think is to her credit that she worked that hard. It shows that she was at this restaurant for days on end, working at the restaurant. She was mistaken about when the conversation occurred. But if the defendant's willing to admit that she told the truth about being offered a bribe, why is she now a liar when it comes to this particular fact? The other thing she indicated is that Lyle Menendez had asked her to gather cases. And the defense made much about the fact that she gathered cases in which people had gotten off. And so they brought in a legal expert, someone who graduated from Yale University Law School, which is one of the finest law schools in this country, an editor of the Law Review, which is very difficult to do. You've got to be in the top of your class. And it took somebody from Yale University who was on the Law Review to explain these concepts to you. Lawyers go to school for 3 or 4 years to learn legal terms. It's very clear that Ms. Bozanich is not a lawyer, and gotten off is in the eye of the beholder. If you're charged with a crime and there's only one crime you're charged with and you are found not guilty, you got off. But in a case such as this, when you could be convicted of first-degree murder, second-degree murder, voluntary manslaughter, involuntary manslaughter, there is a huge range and there's a huge difference there. And so what one person might consider gotten off is another person's terrible conviction. But I think it was very clear that Ms. Bozanich's sophistication in the law was far different from the legal expert who was called in to try to explain this to you. And it's very clear that gotten off is not a legal term. It is something that is used by laymen to say the person wasn't convicted of everything that the prosecutor was asking for. But I think that there's a very logical explanation for that. And in fact, I asked the legal expert, whose name I can't pronounce, where do lawyers go to learn the law? Lawyers go to cases to learn the law, the same kinds of cases that Ms. Bozanich Xeroxed for her boyfriend. And she said that there were little synopses at the front of the cases that she read. And the legal expert had to concede that, yes, these cases do have little synopsis at the beginning, which sums up what the case is about. So the thing is that Ms. Bozanich gives damaging testimony. And I'd like to point something very interesting out. In this case, whenever the prosecution can prove something conclusively, the defense will admit it. Whenever the prosecution has to prove something based upon the credibility of the witness, the defense goes after that witness as if the witness were Attila the Hun. The witness is a liar, the witness is motivated by greed, or the witness is a horrible person. But none of these witnesses that have come forward to testify have ever been convicted of murder. They're not murderers, they're not felons, they are human beings. And the people in the courtroom who have the motive to lie are the people sitting over at the end of counsel table. They are the ones with the motive to lie. So keep in mind the fact that just because a person comes in here and says something, and just because the defense attorneys are able to confuse them, I mean, that's what attorneys are supposed to do.
Excuse me, that's a proper argument.
Overruled, you may continue.
Any attorney who's been doing this long enough, and I can do it too. I have a 10-year-old niece, and I can cross-examine her and trick her and confuse her all the time. That you, as an attorney, you learn how to cross-examine people, and cross-examining is a skill, and in some cases, it's an art form. But just because someone is good at cross-examining doesn't mean that the person who's being cross-examined is a liar. It just means that they are in a battle with someone who's got skills that they don't have. And being cross-examined is very difficult. Some of you probably have friends or relatives. I have a father who's great at cross-examining me. He's not a lawyer, but he was always able to make me feel about this big whenever he started asking questions. So cross-examination is something that is a skill, and Ms. Bozanich was thoroughly and completely cross-examined. But it took a legal expert, somebody who went to Yale Law School, to come in here and explain to you why her using the word gotten off was incorrect. And I don't think that that particular impeachment is very probative in this case. Now, Miss Surya was brought in to indicate that we know that Miss Surya, she was the maid who lived in the house. She wasn't there the weekend that the murder took place, but she was there that Thursday night when there was this horrible, horrible fight that Lyle Menendez indicated he could hear from inside of his guest house between his brother and his mother. And if he could hear it from the guest house, which we know is in the backyard and which is somewhere near the maid's room, how come the maid didn't hear it? And how come the maid never saw any signs of things that the defense claims have happened in this house? So because of the fact that she lived in that house and lived there for long periods of time, her testimony was important to rebut the idea of this horrible fight occurring on Thursday night. Mr. Brian Anderson came in, and Mr. Anderson told us many things, and one of the things he told us is how the estate paid for the defendant's defense. That was something that came out in cross-examination of Mr. Anderson. Now, the defense, of course, wants you to believe that Mr. Anderson is a horrible, rotten person because he loved his sister and he came in and he testified for the prosecution. I'm sure that testifying for Mr. Anderson was very difficult. It is hard even for me to imagine what it would be like to be a relative of the people in this case, because I'm sure that all of these people loved the defendants. And it's very clear from the testimony of the Beralts and people like that that they did love the defendants. But Mr. Anderson came in order to contradict the horrible picture painted of his sister Kitty. He was the closest one to her. She told him her secrets. She discussed things with him. And he was here to give you a brief, small glimpse of the fact that Kitty Menendez was a human being who was not all bad. And that was why Mr. Anderson was here. And coincidentally, it came out during cross-examination by Ms. Abramson that Mr. Anderson was one of the key people in negotiating the fees for the defense attorneys. And Mr. Anderson indicated that the defendants lied to him and told them that they hadn't committed the crime. And then sometime after he had arranged for the fees to be paid through the money of his dead brother, dead sister, and brother-in-law, then he was told that in fact they had done the crime. He is another person to whom the defendants specifically lied, and he indicated that he had spoken to each of them and they had told him they didn't do it. So Mr. Anderson's testimony is there somewhat to portray Mrs. Menendez as a human being who was not a rotten, horrible person, and coincidentally to explain to you how this defense came to be. Marzi Eisenberg was the secretary of Mr. Jose Menendez, and I think she was fairly frank in her assessment of him. She said that he was often hard on people. She indicated that at times she would even tell him, hey, I think you were a little hard on that person. She indicated that Mr. Menendez was pretty transparent to her, and she could tell if he was in a bad mood. There are people you work with sometimes, and you can never tell if they're in a good or bad mood because they're always the same. And then there are other people you might work with or live with where you can tell all the time, this person's in a rotten mood today, I'm going to stay away from them. Marzi Eisenberg indicated that Mr. Menendez was one of the latter type. He was the kind of person where she could tell if he was in a good or bad mood. And she said that on August the 18th, there was nothing remarkable about him. Well, if on the night before, Lyle Menendez had threatened to expose his father as being a child molester to everybody in the world, it seems to me that he probably would have been in a bad mood. True or not, any person in that particular position who had a temper, and we know that Mr. Menendez had a temper, would have been in a rotten and noticeable bad mood on August the 18th. Ms. Eisenberg was also called and did testify that Mr. Menendez had good qualities to him. After the picture painted by the defense, I think it's incumbent upon the prosecution to try to set some sort of balance to this horrible picture that's been attempted to be painted by the defense attorneys. The other thing that Marzi indicated, and I discussed this earlier, is the fact that in the fall of 1986, Eric Menendez was alone with his father many times in Calabasas while the mother was closing up the house in Princeton, a period of time during which Eric Menendez said he had no sexual contact with his father. Karen Farrell was here to testify on behalf of the Menendez parents. She indicated that she had witnessed Mr. and Mrs. Menendez hug their children. She indicated as well that she had talked to Mrs. Menendez on the Tuesday or Wednesday of the week of their homicides, and that she was invited to play bridge with them, that she called and said, I don't think we can make it, and Mrs. Menendez urged her to come anyway. Again, this belies the picture painted by the defendants of the events of the week of August 15th through August the 20th. And Detective Zoller was called for several things, but basically to impeach Ed Fennell about his statement to the prosecution and the police, wherein he said that Mr. Menendez was very unhappy about the fact that Eric Menendez had turned down Berkeley. Now, the defense witnesses, and I'll go through them briefly, Mr. Slotkin was here to talk about the soundproofing. He was here to talk about the defendant's helplessness. I'd like to ask you again to consider if Lyle Menendez, and remember, Mr. Slotkin met with both the defendants. If Lyle Menendez was on the East Coast from the 25th or 26th of August through at least the 6th or 7th of September, When was it he talked to Mr. Slotkin about things such as buying the car? Remember, Mr. Slotkin said that he talked to him about buying the Porsche. Well, Lyle Menendez bought the Porsche on the 8th of September in Princeton, in the Princeton area. There's no evidence he was in Los Angeles between the 25th of August through that time period, except for the one day he came back here. And it's clear that's not the day when he met with Mr. Slotkin. So it appears that they met with him before they went back east and before even the memorial service in Los Angeles. I've discussed the legal expert. Mr. Custer was here to indicate that Jamie Pizarczyk was either lying or mistaken about her engagement to Lyle Menendez. I believe she said she didn't remember it. It could also be that Ms. Pizarczyk is embarrassed. And I think that I might be embarrassed as well to have been engaged at one time to someone who turns out to have been a murderer. It's not the kind of thing that you want everyone to know. And yes, she did come in and testify, and Mr. Custer very briefly gave testimony that at one time she was very excited about being engaged to Lyle Menendez. This was at a period of time before Lyle Menendez had told her that he'd killed his parents. Mr. Peckins gave you a video. Mr. Peckins was the one with the video of the neighborhood. And I think what it showed is that the neighborhood was a very nice neighborhood. The houses are very attractive. I think the purpose of the video is to show that the houses are close together. Therefore, the shots from the shotgun would have been heard by the neighbors. Let me just say this. If you have an alibi for a particular event, one of the things that you need for the alibi is the time when the event occurred. In other words, if they had stabbed their parents and there was no noise, and there was no way to establish when their parents had died, then their alibi wouldn't be any good, because their alibi was for a period of time from 8 o'clock at night to approximately 11 o'clock at night. So unless the neighbors heard something, there was no way for their alibi to have any meaning, because they have to pinpoint the time that this crime occurred. So rather than being something that Dr. Burgess indicated was very, very stupid, there's no way to have your alibi work unless you can establish precisely at what time the crime occurred. Mrs. Ingram and Mrs. Valdry were the people on Mr. Bartek's route. He indicated on a piece of paper 3 names of people he serviced on Saturdays. He thought that perhaps 2 out of the 3 he would have serviced in 1989. Mrs. Ingram said not in 1989. Mrs. Valdry said yes, in 89 he serviced me. Now, I think the defense is going to say that Mrs. Valdry is a liar, because she told the defense investigator, Ms. Erdely, indicates that Ms. Valdry told her something else. Now, why would Ms. Valdry come in here and lie? I mean, what possible reason would she have to come in here, raise her right hand, swear under penalty of perjury to tell the truth, and then lie about when her pool man comes? It seems to me that there's no indication she knows anyone in this case. There's no indication she has an axe to grind. She actually supported Mr. Walker in her testimony, and I don't know if it was sloppy bookkeeping on the part of Ms. Erdely or what, but the idea that that lady came in here and lied is extremely offensive. Why would she do that? She didn't do that. It's just that the defense made a mistake in calling her. Now, I mean, there's just no reason that you would lie about when your pool man comes to your house. What possible motivation could she have? Mr. Heffernan, I've indicated before why his testimony is significant. He's here to say that he's not the guy that Mr. Walker would have seen. Well, I think it's pretty clear that these defendants were not playing tennis exclusively with Mr. Heffernan. And the gentleman that Mr. Walker saw was someone with dark hair. By Mr. Heffernan's own testimony, he wasn't with the defendants on Saturday, that particular Saturday. So it's entirely possible that what Mr. Walker saw is what he saw, which is a man with dark hair playing with the defendants. We know from Lyle Menendez's testimony that during his life he's had over 50 coaches, and that he was coached by many different coaches at the same time on the same occasions. So Mr. Heffernan actually ended up turning out to be a pretty good witness for the prosecution, because of the fact that he indicates he gave Eric Menendez a tennis lesson between 9 and 11, or 9:30 and 11:30 on the morning that they were supposed to be in Santa Monica and then on the way to San Diego. And the KABC tape I've already discussed. Now, the last part of my argument. In a book called Mein Kampf, the author once wrote, "The great masses of the people will more easily fall victims to a big lie than a small one." The judge is going to instruct you at the beginning of the instructions on how you view the witnesses in the case. And as I said earlier, the defendants, once they take the stand, are witnesses. He's going to say to you, a witness who is willfully false in one material part of his or her testimony is to be distrusted in others. You may reject the whole testimony of a witness who willfully has testified falsely as to a material point, unless from all the evidence you believe the probability of truth favors his or her testimony in other particulars. In other words, this applies to the people's witnesses as well as the defense witnesses and to the defendants. A witness who is willfully false in one material part of his or her testimony is to be distrusted in others. The defendants lied a great deal before they were caught. What makes you think they would stop lying now? What makes you think that after all the lies that Lyle Menendez told before, in order not to be captured, he wouldn't lie in order not to be convicted? The judge is going to instruct you. If you find that before this trial, the defendant made a willfully false or deliberately misleading statement concerning the crimes for which he is now being tried, you may consider such statement as a circumstance tending to prove a consciousness of guilt. However, such conduct is not sufficient by itself to prove guilt, and its weight and significance, if any, are matters for your determination. Another instruction he's going to give you, and I'm just reading parts of these. If you find that the defendant attempted to persuade a witness to testify falsely, you may take that into consideration. We know that Lyle Menendez lied to the police during the 911 call that he placed to the Beverly Hills Police Department. We know that he lied to the police officers who arrived on the scene. We know he lied to Sergeant Edmonds shortly after being taken to the station. We know he lied to Detective Zoller. We know that he lied to family members, specifically at memorial services. And I believe at the Princeton Memorial Service, he actually got up and spoke. Can you imagine the coolness and the nerve that must have taken? To know that you've killed your parents and then to get up and speak as if you were the aggrieved victim. He lied to reporters. He indicated that he talked to reporters and tried to portray himself as the grieving son of these slaughtered people. We know he lied to Brian Anderson in order to get his attorneys paid. We know that, according to the defense, they say he lied to Dr. Oziel. You see, when it's convenient for their purposes and they want you to disbelieve Dr. Oziel, they say, well, he lied to Dr. Oziel. But of course, he didn't lie to Dr. Oziel. We know he lied to Jamie Pizarczyk. Now, he admitted that he lied all those times because can you imagine if he'd come into court and taken the stand and denied that he'd lied? Can you imagine what you would think of him? The prosecution could prove all these different lies because in proving he did the murder, we proved that he lied. And so he had to take the stand and say, yeah, I lied before. Because if he hadn't admitted he was a liar, you wouldn't have even begun to listen to anything he had to say. You see, the prosecution boxed in these defendants with the evidence, and the defendants have to admit certain things in order to have any chance of getting what they want out of this case. Now, I'd like to ask you to think about the following. If an actor like Robert De Niro or someone like that had 3.5 years to sit and think about a script, and 3.5 years to get ready for a performance, do you think he could do it? Do you think an actor, a professional actor in 3.5 years with only one script to study and one purpose in his life could get ready and act? Well, this defendant is more motivated than any Academy Award seeker because he's motivated by things outside of praise or money or promise. This defendant is fighting for his life. Now, if he was willing to lie and lie and lie to everybody in town, why, in God's name, should you listen to anything he has to say? Well, he takes a stand and he gives a very stellar performance. He cries at appropriate times. He cries and apologizes to his brother, and he says, oh, and I'm so sorry for what I did to you. And I said to him, come on, is that the first time you've had to apologize to your brother? That was done specifically to move you. Now, I went to a movie recently. I think it was called Mrs. Doubtfire, and it's a sort of a light comedy. And I cried through the whole movie because I always cry at movies. And I was sitting there thinking, this isn't real. This didn't really happen. This is a movie. But I still cried through the whole thing because there were parts of it that I found very poignant. Well, likewise, the story, the tale, the script that was given to you by the defendants on the stand was poignant. And some of you might have felt your heartstrings being pulled. But this is from a person who admitted that he lied to everybody in town. Now, going through the events of August 15th through August the 20th, and if I said, if you believe that Mr. Menendez was a child molester, okay, if you believe that, that doesn't mean the defendants are not guilty of murder, because you can't believe what they said to you about the events between August the 15th and August the 20th. Through cross-examination and through the people's case, the people have proved that much of what they said, which occurred during that week, was a lie. And the reason that scenario was developed was in order to play into this unreasonable but honest belief in the need for self-defense. It's absolutely geared towards the voluntary manslaughter and involuntary manslaughter instructions. So on August the 15th, according to the defendants, Mrs. Menendez ripped off Lyle Menendez's hairpiece, which set in motion the events which culminated on August the 20th. Well, Ms. Pizarczyk indicated in her testimony that Eric Menendez had told her months before that he knew that his brother wore a hairpiece. In addition, it seems to me that if you live with a person long enough, you might notice that their hair is starting to go. You also might notice that the person's not getting haircuts when you're getting haircuts. It seems to me impossible to believe that Eric Menendez did not know that his brother wore a hairpiece. In addition, you've seen a lot of photographs produced by the defense, but have you seen any photographs of Lyle Menendez where his hair was balding? Now, I believe Ms. Pizarczyk indicated when he was 19 years old, it was noticeable that he was losing his hair. Where are the pictures from the defense to show how absurd it would be for Eric Menendez not to know that his brother wore a hairpiece? So common sense tells you, leaving aside Ms. Pizarczyk, common sense tells you that this whole thing with the hairpiece is just something that's totally made up. And in addition, you will see the documents, I think it's Exhibit 372, where on the 28th of July, Lyle Menendez had his hairpiece reattached with the fusion method, which is glue. He indicated he had his hairpiece glued on. It seems impossible that this woman, who was approximately 5'4" to 5'5", reached up to her 21-year-old son. Remember, he's 21. He's not a child. He's not a boy. He's a man. And ripped this thing off his head. And he just, stood there and let her rip it off? I mean, you would think that he would have held his head or something like that. So this whole thing is ludicrous. And Ms. Pizarczyk's testimony isn't even necessary in order to you just need to use your common sense to see how ludicrous it is. On Wednesday, it doesn't appear that anything of major significance happened. But on Thursday, August the 17th, Lyle Menendez had the big talk with his father. He indicated that after the talk, Eric Menendez found out that his mother had known all along about the abuse and had done nothing about it. There is no indication in anything of Kitty Menendez's that you have heard about or that you will see in her letters that she ever suspected her husband or thought her husband was a child molester. The reason that this is being brought up is because child molesting is such a horrible crime that if you believe Jose Menendez was a child molester, the defense is hoping that you'll ignore the actions of the defendants. Lyle Menendez, and I've said this 3 times, I'll say it quickly once more. He says he heard screaming from inside the guest house as his mother and Eric raced from inside the main house across the yard and upstairs into the 2nd floor of the guest house. But of course, Miss Surya heard nothing. And if the neighbors could hear the shotguns, why couldn't Miss Surya hear the screaming? On Friday, August the 18th, Lyle Menendez indicated that his brother was playing tennis and that he went to him and said, hey, it's not a new day. You can't make this thing go away. And they went to buy the guns. Well, we know from Mr. Heffernan that during the period of time when they were supposed to be buying the guns, that in fact, he was giving a tennis lesson to Eric Menendez. We know from the defense preemptive strike and also from the stipulation of the prosecution that they didn't sell handguns at the Big Five. And Eric Menendez was very clear that they picked them out, they were about to buy them, and the man told them about the 14-day waiting period. That is a big lie. They said they went to the Big Five in San Diego for reasons which defy common sense. The reason they went to San Diego so they wouldn't be found out, not because they just happened to find themselves there. Eric Menendez, he had another false ID, but he decided to use Donovan Goudreau's because he looked like Donovan Goudreau. You have a copy, it's a Xerox copy, but you have a copy that's going to be an evidence of Donovan Goudreau's driver's license. And there is no resemblance, aside from the fact that they're both white males, between Donovan Goudreau and Eric Menendez. The reason he didn't want to use his false ID is because it had his picture on it. And when you see this exhibit of Donovan Goudreau's, you'll see that the prosecution can get copies of driver's licenses even after the license is lost. Consider the fact that they used a false identification, a false address, a false birthplace in a city 2 hours away. And I believe Detective Zoller testified that there were approximately 100 gun stores that sold shotguns within a 10-mile radius of the Menendez home, which is where he had concentrated his efforts. On August the 19th, according to the defendants, they went to Van Nuys in the morning to buy more potent shotgun shells, from birdshot to buckshot, because they felt that they might, These non-experts in the use of shotguns felt that they needed stronger ammunition. And so they went and they bought buckshot and drove around. I think they went to a mall out here and had lunch. And then they returned around 4 o'clock in the afternoon. Well, Mr. Walker was really specific. I remember the day that I heard that President Kennedy was shot. I remember hearing about this. I know I was there on Saturday. And he called up Michael Jackson incensed and repeated under a pseudonym what he had heard and what his impressions were of what he saw on August the 19th. The defendants indicated that this fishing trip with their parents was something that they were very terrified of, because they thought maybe this seedy-looking fishing captain and his two mates were going to, I guess, make them walk the plank or something, and that somehow they would come home and Mr. and Mrs. Menendez would say, well, we went fishing and they got lost and we don't know where they are, and they just go on with their lives. Now, remember that in order for you to find the defendants guilty of voluntary manslaughter, you've got to find their belief in the need to defend themselves to be honest. And honesty is something that you can never use to describe Lyle and Eric Menendez. They are the antithesis of honest. On August the 20th, the defendant said that Perry Berman told him that his father had told, this is very complicated. Lyle Menendez said in his testimony that when he called Perry Berman at between 4 or 5 o'clock in the afternoon, Perry Berman told him during that conversation, Mr. Menendez had said, A, that the boys weren't home, and B, that they couldn't go out that night. First of all, for Mr. Menendez to think his sons weren't home, from Lyle Menendez's own testimony, which of course isn't true, but even from his own testimony, he said he never went into the house that day. He stayed out in the guest house. And it's very confusing because you may want to analyze everything Lyle Menendez said as being true, but those events between August the 15th and August the 20th are not true. What happened is during that period of time, they were scheming to kill their parents. And although they did some of the activities they've testified to, like going to San Diego to buy the shotguns, they didn't do it for the reason that they said they did. Now, can you imagine if these defendants had come in here and said, we didn't purchase the shotguns? Well, I have all the evidence to prove that they did. So then what do you think of them? You see, Lyle Menendez had to admit that they bought the shotguns, and then he had to come up with an explanation. And the question is whether you find that explanation to be credible or not. The description of how the murders occurred is something that I'd like to discuss with you now. Dr. Golden's testimony was fairly precise, and he indicated that there were 6 areas of wounding to Mr. Menendez and 10 areas of wounding to Mrs. Menendez, and I'm going to go through them briefly. Mr. Menendez had a contact wound to the back of his head, which Lyle Menendez did finally admit he had done, but didn't really recall the details of it. Mr. Menendez had a distant shot to the right arm, which entered through the underside of the arm and fractured his humerus. Mr. Menendez also had a wound to the back of his right forearm below the elbow. And you can see photographs of these, so you don't have to take my word for it. So he's got a wound entering his arm here and a wound entering his arm from here. And of course, if his arm was like this or like this, there's no way of telling exactly where the arm was. But if Mr. Menendez was seated on the sofa and someone was standing behind him, that would as well explain this wound to his right forearm. Mr. Menendez also has a very interesting wound, which the defense cross-examined the expert about. And what that was is an entry wound above his left knee that went out. Now, it seems to me from the description given by the defendants of how they killed their parents, that they in no way ever described how that particular wound entered the inside of his left thigh and exited on the outside of his left thigh. But the logical explanation for that is that that wound was inflicted from behind him by his assailant. In other words, he was sitting on the sofa, his foot was on the coffee table, his left leg was bent, and someone from behind him shot through this wound. Now, the sixth one is not a separate wound, and it's just an abrasion to his chest. I believe it was, the coroner thought that there was one pellet that entered his chest, and the coroner thought that that was related to the wound that went through his arm as well. So on Mr. Menendez, we have 5 distinct wounds, 5 distinct shots. Mrs. Menendez. Mrs. Menendez had a contact wound to the left cheek, which contained bird shot. Lyle Menendez admitted that he went back in after reloading his weapon. And don't you think reloading his weapon shows a great deal of malice and premeditation and a desire to make sure that she died? Contact wound to her left cheek, which according to him was the last wound. That's wound number 1. She also has a wound to her right cheek and eye, which you can see in the photographs, and she's got a wound to her right jaw and collarbone. The coroner indicated that these 2 wounds to her eye and her chin and collarbone could have been the same. Now, interestingly, there's a part on her face right here that doesn't have any wounding. And so I think, and you know that her right hand had pellet wounds in it. And so it might be that she had her hand up like this when that blast hit her. But the interesting thing about that is that these pellet wounds on her hand were through and through. And yet in the area that would have been covered by it, there are no marks on her cheek. But giving the defense the benefit of the doubt and calling this wound to her right side and this wound to her jaw one shot. Go on to the wound number 4, which was the bird shot to the left ear area. Remember, the coroner said that her left her left shoulder was blown away and that there was bird shot in her neck right here on the left. And he felt that this wounding was from one shot. Well, if it traveled across her shoulder and went up into her neck, it seems that that was done from some distance because he indicated it was a distant shot. But the interesting thing about this wound is it's bird shot. Now remember, the defendants, before they went in first to shoot their parents, they went out to the car, they unloaded what was in their guns, and they loaded with buckshot. So when we do the math at the end, you'll see that this wound, it takes off her left shoulder, goes into her neck, and the contact wound right here on her face were probably administered at the same time. Wound number 5 is to the upper right arm and right forearm. You'll see a photograph of her where there's a wound across her forearm and takes off part of her upper right arm. The coroner indicated that although there are 2 defects there, that's probably the same shot, and that would be wound number 5. Wound number 6 was a distant shot to the left chest and arm. You can see that some of the pellets lodged in her left breast. There was also some wounding, I think, across the left forearm. There's also wound number 7, which is a distant shot to the upper left hip and thigh area. And there was also a shot to the left knee behind. Well, that means she was shot from behind. Now, remember Lyle Menendez when he said, and I'm sure he sincerely regrets this, "My mother was sneaking away." This woman was shot from behind. And then wound number 9 was called by the coroner a graze or a gutter wound. And that was caused by a cluster passing by. And it sort of just took out some skin as it went by. But the interesting thing about this is that the wound goes up as if towards the head, which would imply that the shooter, if she was standing when she got this wound or seated, that the shooter would have had to be on the ground. So it seems like she was in a different position than standing or seated when she got the wound to her left leg. And I'm not even going to count that as a separate wound. And the last wound is wound number 10, which was the wound to the hand, which, as I indicated, could have been, and it would make sense that she would have covered her face with it. And yet, even though it goes through and through, there are no marks on the area that would have been covered. So if you combined, if you have wound number 1, 2 and 3 were probably the same. You have 4, 5, 6, 7, and 8. I'm not going to count the graze wound on her, and I'm not going to count the wound to her hand. So she was shot 7 times. Mr. Menendez was shot 5 times. That's 12. And then we have 2 in the door, which is 14. Now, The guns each hold 6 rounds, and even though the defendants were very unclear as to whether they had fully loaded their guns, for their benefit, we will say that each gun was fully loaded with buckshot when they first went in. Well, that's 12 rounds, and we know that 14 rounds were fired. And we know that 2 rounds that hit Mrs. Menendez, the wound to her cheek and the wound to her shoulder and her neck, were both bird shot. And so if you do the math, it's very clear that she wasn't shot once when they came back into the room. She was shot twice. Now, the other thing about August the 20th, which is remarkable, and I'm almost done with my argument. Remember, Miss Erdely came in and she said, well, I got a videotape from the prosecution, and we went out and we did the driving time, and it took 50 minutes to drive from the house to the theater, back up to Coldwater and Mulholland, and then down to the Taste of LA. It took 50 minutes to do that. Interestingly, if the murders occurred at 10 o'clock and the phone call to Perry Berman is 11:07, that gives the defendant 67 minutes to go to the theater, buy the tickets, go to Mulholland and Coldwater, find a place, hide the guns, come back down into the flatlands, get rid of their clothes because they weren't going to go see Perry Berman with blood on them. Remember, Dr. Burgess testified that they would have had blood on them as a result of the shooting. You can't go meet your alibi witness with blood on you. It could be very incriminating later. They did not do that after. They did it before. And then they went to the Taste of LA, where Lyle Menendez indicated he got lost a little bit. Now, when Miss Erdely did it, her activity times and her driving time came out to 66 minutes, which means that it's possible. But unfortunately, she assigned her own activity time instead of the activity time testified to by Lyle Menendez. Lyle Menendez indicated that first of all, he's unfamiliar with the roads here in Los Angeles. And if you've ever been on Coldwater, and you can see from the videotape, it's a winding road and it's not well lit. He indicated that after they murdered their parents, they waited for 5 to 10 minutes at the house for police. They discussed what they were going to do now for approximately 2 minutes. They evidently recovered from their automaton, fearful state. They went in and picked up the shells, which took a minute, and they left the house. The best they do with this particular activity is 8 minutes, and that's giving them 5 minutes to wait at the house, 2 minutes to discuss what to do, and 1 minute to pick up the shells. So you've got 8 minutes for activities. If the driving time is 50 minutes and the activity time is 8 minutes, you're up to 58 minutes. You've got 9 minutes left to do everything else. They go to Century City, where Lyle Menendez indicates he parked at a parking meter. There are no parking meters outside of Century City. There is no taxi place. There's no place where you can leave a car unattended. And Eric Menendez went with him up to buy the tickets. He indicated it took approximately 10 minutes to park the car, go to the box office, and purchase the tickets. Well, at this point, there are only 9 minutes left. So already by then he's used up his allotted activity time. Then they went up to Mulholland, they buried the guns, and in 2 minutes, this was all accomplished. Detective Zoller testified that there was a lot of brush up there. There's no lighting. I believe, but I'm not positive, that Eric Menendez said he went about 150 feet down the hill in order to hide the guns. And this all took 2 minutes in the dark, no lighting, with a lot of brush. But still, giving them that, they are now 3 minutes over their activity time. Then they went and got rid of the clothes, and I believe this activity took approximately 5 minutes. So they're now 8 minutes over their activity time. Lyle Menendez indicated that on the way to the Taste of LA, they got lost for a period of minutes. So let's give them 2 minutes for getting lost. They're 10 minutes over the amount of time they would have had to do this. It would have taken, they wouldn't have made the first call to Perry Berman till 11:20. What actually happened is they went to the movie theater beforehand to buy the tickets. And one of the things that's a problem for the defense in this case is that it's very clear they had to have gone to the movie theater, because Lyle Menendez was able to tell the police License to Kill was sold out. Well, you all know from going to the movies that when you call a movie theater, you get a recorded message, and they don't tell you, oops, License to Kill was just sold out. The way you find out a movie is sold out is you go to the theater. See, we can prove then that Lyle Menendez and his brother went to the theater, because shortly after the homicides and the police are called, they're telling the police License to Kill was sold out. At the time, it seemed like a clever move because it proved that they went to the movie theater. What really happened is they went to the movie theater before they killed their parents and they bought the tickets. And I believe the tickets were given, and I think the testimony was, is the tickets were given to Eric Menendez, who put them in his pants pocket. That's where you put your movie tickets if you don't carry a purse like a woman does. All right, so puts the movie tickets in his pants. They do the murder. They go and they change their clothes. And what does Eric Menendez do? He changed his pants. He threw his pants away in the dumpster at the gas station. There went the movie tickets. Now, it turns out to be a very fortunate thing, because if he hadn't thrown away the movie tickets and he'd given them to the police, that would have proved that the movie tickets were bought beforehand. But now they can come into court because he made this mistake and say, we went to the movie theater afterwards and we found out what we found out then. But we know that there was not sufficient time between the 10 o'clock when Mrs. Lord said that she heard the sounds and the 11:07 record, the U.S. Sprint record that we have. See, it's another thing we have that they have to explain. We have the U.S. Sprint record, which shows that at 11:07, a phone call was made to Perry Berman from the Santa Monica Civic using Mr. Menendez's Sprint card. So this particular thing, this whole story about making up the alibi afterwards and all the things they did is another lie. So where does that leave them? Well, what it shows is that these defendants have lied throughout. They are lying now, and they will continue to lie as long as they think it will help them keep from being convicted. And I'd like to leave you with this. I don't know exactly how the defense is going to explain the December 11th tape, but in the words of Lyle Menendez, and I'm going to read to you portions of the transcript from the December 11th tape. He says, because even the planning out of this, the reason it took such a short period of time to figure it out was, one, because it could have happened at any moment. He goes on and he says, it was done so quickly and so sort of callously almost, because one, if you thought about it too much, the feelings of not having your parents around and so on would get in the way of what was more important, which was helping your mother, really. And then he says, I think one of the biggest pains he has, and he's talking about his brother Eric, is that you miss just having these people around. I miss not having my dog around, if I can make such a gross analogy. Now, the defense is going to try to tell you that these are the words of Dr. Oziel, but if you listen to the tape, Dr. Oziel never uses the word plan, and he never compares killing Mrs. Menendez or killing Mr. Menendez to getting rid of a dog that you don't like. The truest statement of Lyle Menendez's state of mind is contained on that tape. And although the tape is clearly made to try to mitigate or to try to minimize his moral culpability, when Lyle Menendez uses words like plan and uses phrases such as, I let my brother sleep on it for a couple of days, it's very clear that this was a planned, premeditated slaughter of two people who were keeping Lyle Menendez from doing what he wanted to do, which was not go to school and spend a lot of money. He is guilty of 2 counts of first-degree murder. He is guilty of conspiring with his brother to commit those murders. And he's guilty of killing 2 people, 2 people of first-degree murder. He's guilty of doing it by lying in wait and taking his parents by surprise in order to accomplish his goals. Thank you.
All right, thank you. And we'll take a recess, ladies and gentlemen, to permit the lawyers to set up for the next phase of the argument. If you would return and be ready to return at 10 minutes to the hour, don't discuss the matter with anyone. Don't form any final opinions about it. If you would be available in the jury room so we could have you come in here at 10 minutes to the hour. And I'd ask the counsel remain. The jurors have left. There was some question in regards to the defense argument.
Yes, Your Honor. It's my understanding that Mr. Byrd intends to play videotapes of some of the testimony of some of the witnesses. I think it's just 2 of the witnesses in the case. And the people object to that.
Well, first of all, is that what you intend to do?
Yes, I have a very short segment of Lyle Menendez's testimony and an even briefer segment of Dr. Oziel. I think it's less than 3 seconds in length on Dr. Oziel and less than 15 or 20 seconds on Lyle Menendez. And I intend to use that to talk to the jurors about how they judge demeanor as one of the factors in determining the credibility of a witness. And in response to the prosecution's argument that apparently Lyle Menendez was modeling himself after Robert De Niro and practicing for his testimony. So I do intend to place some emphasis on demeanor, and I think that the most effective way to do that is to bring to mind to the jury something which they saw and which I can recreate in the courtroom in much the same way that the prosecutor can put up her bloody photograph and use that as a basis for her argument. So I think it is proper evidence. It's certainly something the jury heard and saw in testimony. And I think it's an appropriate way to highlight the point that's being made. I'm certainly not asking that the video go into the jury room, but I think it is can be used properly for illustration purposes.
Well, the bottom line is that the jurors saw this testimony, and perhaps they did not see precisely what's on that video, and now you would be presenting to them something they didn't see. They could have easily been looking away at the moment that the video camera caught whatever it was the witness was doing that you want to show to them, and you were in essence showing them something that perhaps they didn't see.
Well, hopefully they were following the court's instructions that they were here to listen and to evaluate the credibility of witnesses.
Well, I hope so too, but that doesn't mean they were watching the witness every moment. Sometimes they look down, sometimes they look at the lawyer asking the question, sometimes they look at the lawyers at the counsel table, sometimes they do other things. So my first observation is that you would be introducing something that they might not have seen. They did hear the testimony, they've heard all the words spoken, they've seen the demeanor of the witnesses, perhaps not the exact expression that you want to display, because, as I said, some of them might not have seen that. And at this point, you are introducing something that perhaps some of the jurors have not seen, and is introducing evidence outside of the trial to that extent, which
Well,
would possibly be the case. Besides that, it tends to accentuate one thing over another, and is, at this point, the court, in its exercise of discretion, sustain the prosecution's objection to
Well,
this.
could I be heard briefly on that? In terms of the court's analysis that it tends to accentuate one point over another, I don't see how that can differ from the prosecutor having a photograph up on the board throughout her closing argument, as she did, and the photograph is still up there. That is the purpose of closing argument, to insinuate what, in counsel's view, is a important piece of evidence.
Yeah, this is a piece of evidence.
It's argument, and so is the demeanor of the witnesses. And I don't think it's the right answer to say that, well, maybe the jury was not paying attention.
No, I didn't say that. I just said they may not have been looking at the witness. They certainly didn't have the same perspective as a TV camera, and they saw something different. And whether they were looking at the witness at the exact moment that you now want to portray is something we'll never know.
But
That doesn't mean they weren't paying attention.
No, but that's not what it's being used for. It's not being to say at this precise moment in time, these witnesses did something that indicates their demeanor at that precise moment. It's something that if at some point in time the jury was paying attention, and we have to presume they were over 6 or 7 days.
Yeah, none of my comments have anything to do with their paying attention. It has to do with whether or not they happen to be looking at the exact moment that you want to bring out in your video, actually seeing exactly what you want to show them now.
But as I indicate to the court, that's not why I'm attempting to use it, to bring to their attention something that they may or may not have seen. It is a point that was, and their demeanor was the same throughout. And the worst that could happen by use of this is that the jury or some of the jurors would see something that they should have been looking at to begin with, which is paying attention to the testimony. So that's the only harm done. And it is argument. It's not being offered for any other purpose than to highlight an argument which I intend to make. And I think an appropriate one in light of the prosecution's emphasis here on play acting. it's the only way to accurately recreate demeanor and to bring that back to the jury's mind in a way that is effective.
All right, there is no need to recreate the demeanor. The jurors were here to see it and observe it and form their own opinions based upon the entirety of it, not just one little snippet. So the court's observations are those that will control it. The court's ruling and the people's objection is sustained. All right, we'll resume in 10 minutes.